Call the meeting to order. Motion to convene into open session.
So moved. Again. Second.
Roll call.
Grenache,
Yes.
Shaw,
Yes.
Brown,
Yes.
Lang,
Keisha, are you there?
I see her.
yeah, I can see her down there.
I can see her, but I can't hear her.
He's on mute. Hey, Keisha, you're on mute. Roll call.
Lang,
Keisha, unmute. There you go.
Lang. Pardon? I'm guessing she can't hear. Okay. Stutz,
Here, present.
Doslager,
Yes.
Aguilar,
Yes.
Toomey. He's not logged in, is he? No.
Good morning. I'm sorry, I didn't hear it. I was on mute or something.
That's okay. Thank you.
Okay. All right. Let's see. Good morning, and welcome to the annual retreat of the Board of Trustees at WIU. As you'll note, some of the trustees are remote and some are present in person. Like the entire campus at WIU, we are proceeding with an abundance of caution and numerous safety precautions, including remote access by several trustees. Of course, just like everyone else, we look forward to a time when such precautions are no longer necessary. Before we move into the retreat agenda, I'd like to take just a moment to recognize that this retreat is the first to commence with a recognition of higher first-year enrollment than in the previous year for the first time since 2011. While our freshman enrollment this year is less than 1/3 of our freshman enrollment in 2011, which was 3,861, freshman enrollment this year is 20% higher than it was in 2019. As the old proverb says, every journey begins with a single step. For the first time in 9 years, we've taken a step forward in our enrollment, and Interim President Abraham, Associate Vice President for Enrollment Gary Swegan, Director of Admissions Doug Freed, our admissions counselors, advisors, and many others who have worked very hard to get us to this point deserve our recognition. On behalf of the board, I offer profound appreciation for your hard work in reversing the enrollment trend. Thank you, and we can't wait to see what comes next. With that said, I'll turn it over to Dr. Abraham, and then we can go on with the retreat.
Yeah, thanks, Polly. I would echo the good news about enrollment and certainly thank the enrollment team that has put all of this together. They've done a phenomenal job this year, and it's been a tremendous experience. The other thing that Polly did not include is not only is the enrollment looking excellent, but so too is the retention. We are at about 77.1% freshman, first-time full-time freshman retention, which is the best we've had in 15 years. And on transfer retention, it's 83.1%, and we've never been that high before. So retention numbers are also looking very good. And the last thing I would say, and it is a really great shout out and a tremendous thank you to really not just to the health folks, the people in the student services area, the health center, the View Health Center, and the student support people who have run their butts ragged for the past 3 weeks, getting this university open and getting us running and getting our students and our faculty and our staff safe. And we owe a huge debt of gratitude to John Smith and his staff who have, 24/7 I think they've worked 48/14, to be quite honest. And They've done a phenomenal job. We could not have done this without them. And huge debt of gratitude to them. So thank you.
Okay, Nikki, would you like to introduce yourself?
Absolutely. Thanks, Pauline. Thanks, Dr. Abraham. I apologize. I hope my internet is okay. I was having a little instability, so hopefully I'm better now. I'm Nikki Baser. I'm a partner at the law firm of FRANCZEK PC. We're a Chicago-based law firm, but we represent entities all over the state. We represent over 100 educational entities, including institutions of higher education like WIU. We represent work for University of Illinois, work for NIU, we do work for University of Chicago, so we have a lot of experience all over the state, ed, boards of higher ed. I'm happy to be here with you. I'm so sorry that we can't all meet in person. I know that this is a difficult time for boards. You guys are trying to run universities remotely, and hopefully our training today will help a little bit. But certainly appreciate all the efforts that you all are making as you struggle through these times. I'm really pleased to be here. I'm really happy to have the opportunity to connect with WIU. I've done a couple of projects for the university. This is obviously the first time that I'm in the board, so very much appreciate you all being here. I know that when you woke up this morning, the thought of spending 4 hours with an attorney was highest on your list on a beautiful Saturday morning, but we'll try to get through it. The purposes of this training are twofold, in my opinion. The first is some of you are still looking to conduct or get your board leadership training as required by statute. So this will fulfill those obligations for you. We'll go through all of the statutory requiremements for that training. Hopefully for those of you who have already had your board leadership training, this will be a good refresher course for you. And then the second portion, we're going to spend some time sort of mid-training talking a little bit about board rules, board processes, board guidelines, board norms. I have some documents that I've developed in draft form that I'm going to share with you all that we can talk through as a way to think through how to make your board function in the best possible way. So we'll spend some time doing that. I am absolutely, as an attorney, able to speak for 4 hours straight. I don't think anybody really wants that to happen. So I know a lot of you have served on this board for a long time, or serve on other boards or in other capacities, work with boards. So if at any point you want to make some comments about how your board has run or some things that you're thinking about on the topics that I'm presenting, please feel free. I've asked, I know Liz is on the line, and I've asked her, obviously my familiarity with the laws and the structures that we're going to present is key, but obviously I haven't spent a lot of time on the ground at the university. So if there are things that you do in a little bit of a different way, I've asked Liz to sort of chime in as well. I'm happy to take questions throughout. I know Zoom is a little awkward. I'm going to be sharing my screen with my with my PowerPoint, but feel free just to sort of start shouting at me. I respond very well to sort of angry shouts. So just let me know if you want to ask a question or talk at any point, and I'm happy to make time for that. When we do get to the documents that I referenced, would love for us to have a conversation about that, to really dig into that. And get your feedback. Again, these are just sort of some ideas to put on the table to think through. So with that, unless there's sort of further introductions we need to make, I want to start. I'm going to attempt to share my screen here. So with my PowerPoint, just give me a second. All right, are you guys seeing my PowerPoint? Just nod and smile. Yes, okay. All right. So again, what we're going to talk about today, or what we're going to do today, is go through the board leadership training. We're going to talk about statutory requirements, the law that exists in Illinois, your governance responsibility as Board of Trustees, and your requirements to comply with your own internal bylaws, policies, and regulations. Again, I'm going to try to make this as interesting as possible. Obviously, some of the topics that we're talking about, lend itself to more entertainment than others, but we'll try to work through these things together. And again, I know for a lot of you, this will be a refresher course, so hopefully it will be interesting from that standpoint. For those of you who are more new to boards, hopefully this will give you a good outline of the types of statutory requirements that you need to be thinking about as you make your way through your board responsibilities. So the first thing that I'm going to talk about, we're not going to spend, we'll spend a little bit of time on the Open Meetings Act. It's a really critical piece of your duties as a board is to comply with the Open Meetings Act. We're going to talk about FOIA. So we'll do Open Meetings Act and FOIA. I'm going to talk through the legal requirements of the Open Meetings Act. We'll talk through the legal requirements of FOIA. And then I have a couple of hypotheticals that I'll go over with you. I will not ask, since we're being recorded live on YouTube and the like, that you answer the hypotheticals, although if anybody wants to volunteer, I'm by all means, but I'm happy to answer them and go through them with you, just to give you, again, just a little bit of the practical reality of how you implement these and how you adhere to them at the board level. Okay. So, and overall, I would say, when you're thinking about the Open Meetings Act and FOIA, really the driving force behind all of both of these laws is to ensure that the actions of public bodies like WIU are done in a way that is transparent, done in a way that the public understands what you're doing as a board, what you're doing as a university, the decisions you're making, and that they're done in a way that the public can investigate and review. So, those are the overarching ideas. They can seem, the sort of specifics of this can sometimes seem very onerous and overwhelming. But again, we're sort of thinking about it from the vantage point of that overarching goal of transparency. So for the Open Meetings Act, the critical thing, of course, to start with is, what is a meeting under the Open Meetings Act? And, it sounds like sort of an obvious question, but I think it's an important one to review. It's any gathering by any means of contemporaneous interactive communication of a majority of the quorum of the members of a public body held for the purpose of discussing public business. So there's like a lot in there that we're going to unpack. Okay, so any gathering. The reason that I stress that is that emailing or texting could constitute a meeting. And the reason that is because of that phrase, contemporaneous interactive communication. So if you guys are texting back and forth or emailing back and forth, and you're doing it about board business, and it's a majority of a quorum of the members, and we'll talk about what that is in a minute, you could be engaging in a public meeting, even though you're on email or even though you're on text message. So you do have to keep that in mind as you think through communications with other board members. Obviously, this is a numbers game. So you have 8 board members. A quorum of the board is 5. So a majority of the quorum is 3. So anytime you have 3 board members in a room talking about public business, that constitutes a meeting. And so if you haven't set it up correctly as a public meeting, then you are in violation of the Open Meetings Act. So again, just important to keep in mind, not only when you're physically present, not only when you're on the phone, but even in those written communications, they could constitute a meeting for purposes of the Open Meetings Act. So there are a number of other requirements, as you can see on the screen. The first is the notice requirement for meetings and for the agenda. So the notice of the schedule of your regular meetings must be posted at the beginning of the year, and each agenda must be posted at least 48 hours in advance of the meeting so that the public knows what you all are going to discuss and can come prepared if they want to listen in on a certain aspect of your meeting or just want to know what's going on. Obviously, as you all know, we are in open session. Open session is the typical avenue for the board to discuss public business. Most of your discussions will be in open session. The default is being in open session where the public can listen in to your meeting. You do have a right under the Open Meetings Act as a board to go into closed session. You can only go into closed session if you are discussing one of the exceptions that is recognized by the Open Meetings Act. a couple important points about this that I think are really critical to keep in mind. The first is you cannot go in for one issue and then discuss others. So I know you guys are probably very adept and familiar with the process to go into closed session. So you state the specific exception in a motion prior to going to closed session. It has to be approved by the roll call vote. If you do not identify an exception in terms of, let's say you want to go in under personnel, but then when you're in there, oh, I want to talk about litigation now. You cannot talk about litigation unless you make clear to the public that you are going to go into closed session on that exception. The other thing is you really shouldn't start talking about anything other than the items that allowed you to go into closed session. And we're going to talk about some what I'll call cautionary tales of other public bodies that did this, to their detriment. I was the general counsel for the Illinois State Board of Education for a number of years, and I would, from time to time have to sort of remind our board members, like, it's great to talk about the movie you saw on the weekend, but we really shouldn't be doing that in closed session. Obviously, that's pretty benign to sort of talk about weekend plans, but what you really have to be careful about is when you go in, intending to talk about personnel, and you end up talking about generally the finances of the university, something that you really can't go into closed session for. So you do have to be careful. You do have to really police each other on this because, as you will see in one of my examples, the discussion could eventually become public if you are talking about things that are not allowable to be talked about in closed session. Okay, so I will not lecture you anymore on that. I know it's a point that is often difficult as people get into those conversations, but it is important to keep in mind. The only other thing that I'll note about the actual substance of closed session that's important to remember is that the board can come to a consensus in closed session. They can come to an understanding of how they're going to vote on something in closed session, but you can't take any action in closed session itself. You have to take all action publicly. Closed session also has, obviously you have requirements under the Open Meetings Act in terms of minutes for, we'll talk about it in a minute. For closed session, you must record the closed session. Obviously the tapes have to be verbatim recordings. Recordings can be destroyed after 18 months after the board approves the destruction and approves the written minutes from the closed session. Something definitely to think about to make sure that you're on cycle to destroy those tapes as needed. And access is limited. To recordings is limited to you, the board members, the trustees, and it has to take place under certain conditions. So allows you access, but not others. So that's sort of my lecture on closed session. Turning to the next topic under the Open Meetings Act to keep in mind or to think about is public comment. Obviously, you all are likely very experienced with public comment. People come and they speak to your board on a variety of things. There's lots of stuff to talk about related to public comment. The things I'm going to just stress for a minute are, any person can come and address you all under the rules established by the public body. You're able to create reasonable rules for for public comment, excuse me. One of the things that is always balanced with public comment is the right for the public to come and talk to you all about their feelings about the board, the university, whatever's on their mind. But we also need to conduct the business of the board, right? We need to get through the agenda. You need to vote on things that are essential for you to vote on. And so you are able to sort of curtail public comment in a way. You can set, a minute, number of minutes that each speaker can speak for. You can limit overall the public participation. There's some other tricks of the trade, that you can use when dealing with public comment to try to make sure that it's not sort of running amok on your meetings. Obviously, if you have something of particular importance to the public, you should and probably likely do anticipate and experience and understand that you're going to have a slightly longer public comment during those times. One of the other things that I like to talk to boards about with public comment is is that, you know, there is a human tendency, which is a great human tendency, that if someone comes to talk to you, that you engage, right? That you talk back, that you answer questions that they might have publicly. I really would caution, though, against the board sort of engaging in a back and forth with the public who come and comment at your meetings. You know, if sometimes it's just you know, obviously thanking them and appreciating their coming and all those things are fine, but a substantive engagement can detract from the overall work of the board. And also, there are times where the public will come and talk to you about something that is really better dealt with by the administration. And so, you know, referring that person to an administrator or asking Dr. Abraham to say, you know, which administrator can we put this person in touch with, or which office should they go to, is often a better course, because then it can be handled in the routine manner in which the university typically handles either complaints or questions or concerns. So we sort of get into trouble when we start, you know, debating with someone from the public, or agreeing with them or responding to them, can sometimes sort of get us amiss in terms of the board's work and also the role of the administration in responding to those types of issues. So again, you know, understandable, you know, people say things, certainly if they are critical of the board, there is sort of a desire to respond. There's lots of avenues that the board has to respond to public concern about how the board is running or how the university is running, that don't involve sort of a off-the-cuff engagement with folks who are engaged with public comment. And so something to consider and think about when you have those moments with the public. Okay, action is the next item on the list. Just of course, final action must be preceded by a recital of the nature of the matter being considered and other information that will inform the public of the business being conducted. It's just a fancy way of saying that you have to explain what you're acting on in a way that the public understands what you're doing. And it seems so very obvious, but I can tell you that there have been a number of Attorney General opinions, and I'll talk about the role of the Attorney General. Obviously, the seal is on my slide. You know, there's been a number of Attorney General opinions about the fact that whatever was being voted on was just not explained sufficiently to the public. So, for example, we often see boards running afoul of this when they're entering into, you know, a settlement agreement, but it's not clear how much the settlement agreement is for or what the specifics are. There are a number of other cases where this comes up, but you do have to be sure that whatever's being described in terms of what action you're taking is clear to the public. You know, having watched part of one of your meetings, I think you do a very nice job of that, but it's just something to keep in mind. So typically, depending, you know, there are some exceptions when the statute says otherwise, but typically an item passes once you take action on it if a majority of those voting approve it. Again, as I mentioned before, all action needs to be taken in open session. You're not taking any action in closed. All votes need to be public. And the last sort of bucket of issues, specifics under the Open Meetings Act that we should talk about is minutes. Board must keep written minutes of all meetings, both closed and opened. The minutes really do need to have some level of detail: date, time, and place of the meeting, presence, who's here, who's on, which trustees are here, which are not, a summary of the discussion, the votes taken, and again, the closed session minutes should reflect what occurred in closed session. Those also need to be reviewed semi-annually by the trustees to determine if they should remain confidential. Again, I had put the Attorney General seal. Many of you likely know that one mechanism of enforcement of the Open Meetings Act, as well as FOIA, which we'll talk about, is a complaint to the Attorney General's office. We refer to them as PAC complaints because it's the public access counselor who deals with them. For those of you who have been on boards under the regime of Attorney General Madigan, and all disclosures, I worked for Attorney General Madigan for a few years, as well as Attorney General Kwame Raoul. They take a very expansive view of the Open Meetings Act. Their decisions tend to, in the Open Meetings Act, and we'll talk about FOIA in a minute, they tend to be, they err on the side of transparency. So when it is gray, they're going to err on the side of openness. So you can file a complaint to the PAC. The PAC will either issue a binding or a non-binding opinion. You can appeal that decision, or you can take a case directly to circuit court. So we do see a variety of avenues that people do. I'm sure that WIU has its share of complaints. No public body doesn't. And that process is, the Attorney General does a good job of allowing boards to present their side of the case and really consider all aspects of it. But as I said, they do tend to err on the side of openness. So again, I had promised some cautionary tales, so I'm going to give you some cautionary tales. This stuff is obviously, it is hard to always comply in every which way, but there have been some notable times when boards really ran afoul. In 2015, at a special meeting, a board of a community college discussed the financial condition of the college in executive session. We talked about that issue before. They went on into closed session under personnel matters, and then they ultimately ended up talking about the financial uncertainties of the college, the financial stewardship, the 5-year forecast, the tax levies, the sort of every part of their sort of financial agenda ended up being discussed in closed session. If memory serves from this case, I believe that the reporter who filed the complaint, actually could see the slides. They actually had slides prepared. And he could see the slides from sort of, the door was slightly ajar to closed session. So he could see, the topics, and he filed a complaint. And the Attorney General found in favor of the complainant against the board of the community college, finding that, the very brief conversation about personnel or employees was not sufficient to that. They then went well beyond that, talking about the financial conditions of the university. So the reason this is such a cautionary tale is that, amongst other things, they were required to make both the recording and the slides available to the public. So that closed session became a public session. So keep that in mind. Another cautionary tale that you all probably are familiar with, because it happened not too long ago, but there was a member of the public who complained that the board of NIU violated the Open Meetings Act when they were presenting the severance package of the president, and the allegations were that they didn't provide proper notice of the meeting, that they didn't provide a full description of the agenda item, and they didn't make a required performance review, which was required under a state law that regarding public universities and severance agreements. So ultimately, in 2017, a judge did rule that the severance package was null and void because of the violations. And eventually, not only that, which was of a huge issue for the university, they also had to pay the plaintiff's attorney's fees, because this went all the way up through the courts, which were over $55,000. So, important to keep in mind that there are real ramifications. Obviously, minor violations of the Open Meetings Act, even if they get a complaint to the PAC, they'll probably say, listen, don't do that again, or make sure you're keeping in mind those issues. But there are some significant consequences if the violation has an impact on the workings of the board, the trustees, or the university. So that is the Open Meetings Act in somewhat of a large nutshell. I'm going to pause for just a minute to see if anybody has any Open Meetings Act comments or questions that they want to raise before I move on to FOIA. Okay. I'm happy also if someone down the road decides, oh my God, I just had this really amazing Open Meetings Act comment or question. Feel free to voice it later. I'm happy to circle back on some of these issues if any questions come up as we go through. Again, we're happy to take questions at the end as well. All right, so let's transition to the Freedom of Information Act. I talked about that a little bit. Again, the legislative intent, just like the Open Meetings Act, the idea is transparency, full and complete information regarding the affairs of the government, the acts and policies, the things that you do as public officials, as a public board, as trustees, and all of the university. So again, accountability, transparency. The act is not intended to invade your personal privacy or to overburden or disrupt the work of the public body. So there are some ways and some avenues where disclosure is not required that we'll talk about. But again, always a balance between making sure that the documents that relate to the actions of the public body to the university are fully disclosed to the public as needed. So what I'm going to start with by saying is that all records discussing public business are subject to FOIA. I'm going to repeat that because, all of the documents that any public records that are discussing the public business of the university are subject to FOIA. Now, there are exceptions that we'll talk about that allow you to, or exemptions that allow you to withhold documents, but those documents are still subject overall to FOIA. It's any public documents as well, regardless of the format. So again, I know that we're sort of, this used to be an issue. I think everybody is very clear on the fact that your emails and your text messages are subject to FOIA. And we'll talk about, again, some cautionary tales in this regard. So again, all public records must be provided unless there is an exemption. But the presumption is of openness, right? So the exemptions are limited. The most frequently used are that the request is unduly burdensome, there is personal information, or that a document is pre-decisional, meaning that it expresses opinions about something, but it isn't the final action or document of the Board of Trustees in this case. The information can't be released under law, and that will loop in, for example, your student records, bid documents before final decision, and records related to specific aspects of disciplinary cases for students and as for employees. So there are a number of other exemptions. Those are the ones that we see used most often by boards of trustees. But again, the default is that these are public documents. So definitely, we'll talk about keeping that in mind. One thing I want to add, because I think this is important for universities to consider, is that public records may encompass more than just the records of the public body itself. And I would point you to the decision that came out in 2017, which you may all be aware of. There was a PAC decision about the College of DuPage Foundation. So that was actually, it all went all the way up to the appellate court, and they held that the College of DuPage Foundation had to disclose a federal subpoena that they had received that they had fought to keep private. And what the court found in that case is that while the foundation itself was not technically a public body, it was subject to FOIA. And what the court said was that the foundation wasn't just soliciting donations for the College of DuPage from private citizens, from donors, but it also, one of its roles was to hold all of the private donations to the college, even the ones the foundation didn't itself solicit. And so essentially what the court was finding is that they were contracted to perform a duty that directly related to the government function of the college itself. So essentially the college was asking it to perform a duty that the college would otherwise be performing in its duties as a government entity. And so all of its records were subject to FOIA. So again, something to think about. So, again, there's a number of cautionary tales here. I don't want to belabor these points too much, but I do think it's worth keeping in mind that there are some pretty high-profile cases that have taken place that are likely on your radar because of just, again, they hit the papers. A few years ago, the University of Illinois, the chancellor was forced to resign after encouraging certain personnel to utilize personal email addresses in an attempt to maintain confidentiality. So essentially to skirt FOIA, she encouraged folks to use their personal email. So Doesn't matter if it's your personal email. Certainly, it's still subject to FOIA if it's discussing public business. But obviously, you should not be attempting an end run around. Likewise, there was some cases out of Chicago under Mayor Emanuel. There were some email chains that related to some contracts through CPS. Some of the email exchange contained personal information, but still required to turn over those email chains because they were primarily about the public business. One case that comes up a lot that people talk about was the city of Champaign. Their council members were communicating, via text and email during meetings. And someone requested basically their communications. And originally they were arguing that because they were on their personal devices, they were not subject to FOIA. And the court, said absolutely not. These are their communications between the board members, like the city council members in that case. They pertain to a transaction of the public business. They've been prepared by those folks. They are used, received, they're in their possession related to the public body. So, one of the things that I always suggest is that you're not texting each other during board meetings. If you're emailing, those are going to be subject to FOIA. So we certainly don't want that to have to sort of delve into those records. Just like under the Open Meetings Act, there's a number of technical requirements under FOIA. You need to have a FOIA officer. There's a certain timelines that you have to adhere to regarding your responses. And there is also the same avenue of appeal to the Attorney General, to the PAC. If you actually look at the PAC's website and you actually go through their binding opinions, what you will see is that for every Open Meetings Act opinion, there's probably 10 FOIA opinions. So FOIA is a really, it's an area where there's a lot of challenge to public bodies. In terms of getting records, there's, lots of folks out there that use the FOIA law and are not afraid to file, requests with the Attorney General's office to review. And again, we see mostly the erring on the side of transparency. So again, it is certainly right and worthwhile to protect documents, particularly ones that pertain to students, to the personal issues of employees. But the default is going to be that those records are most of your records of your public business are going to be subject to FOIA. They're all going to be subject to FOIA, and most of them are going to not be covered by an exemption. So this is always my cautionary slide, which I know you all know, but I like to just put it up there again, just to remind everybody that you should be careful what you write. It could end up on the cover of a newspaper. I'm a really, really big fan of the telephone. So like if you want to complain about this training or whatever you want to complain about, feel free to pick up the phone and call your fellow trustee. Obviously just one of them and not two of them, so we don't run afoul of the Open Meetings Act. If you want to have a conversation with another trustee, by all means, because we do need to, be able to express ourselves freely and blow off steam. But when you put something in writing, please sort of always think that someone is going to be looking over your shoulder and reading that document if it relates to WIU, and make sure that you are sort of cognizant of that. I like to tell this story. It does not relate to a university because I do some K-12 work as well, but I do like to just make this point. I once had a case, it related to an individual student, and at the K-12 level, which is different than at the university level, not always, but usually there's a lot more interaction and correspondence with parents, right? Because those kids are minors. And in this case, we had a very, very communicative parent. And I had, when there was ultimately a legal dispute, and when I got the emails that were both between the teachers at the school as well as communications to the parent from the teacher, I would say I had about a foot of emails on my desk that I had to go through. And it was clear that this parent, and when I say communicative, like, on steroids, right? Like just a huge amount of communication all the time. And there was a lot of communication between the teachers because of that. And I can tell you that there was not one statement in any of those emails that I was embarrassed or concerned about turning over to the counsel for the parent, because in every one of those communications, despite the clear frustration that this whole situation was causing, the teachers were incredibly professional in their tone and in their comments, even just the internal emails. And it was such a great relief, because that can be really bad and it can be really frustrating. So I understand that there's always there's always frustrations that you're going to experience as board members, as trustees. But we'll keep it off the written page, and feel free to yell at your cat at any time, your dog, your spouse, hopefully not as much, but please, be cautious about what you put in writing. I am going to just go through a couple of 3 hypotheticals that relate to Open Meetings Act and FOIA, but I do want to pause and ask if anybody has any questions about the FOIA law before I move on. Okay. I'm either incredibly thorough or everybody is just completely fallen asleep at this point. I can see you on Zoom though. I feel that most people are somewhat alert. So again, appreciate that a lot of you guys know this like the back of your hand, and a lot of this is just refresh for you, but always a good idea. Okay, so hypothetical number 1, again, if people want to weigh in, by all means. Beautiful State University Board of Trustee members, Hugh Handsome and Molly Makeover, are social friends. Sorry about these names. They were written by a colleague of mine who's very clever. One evening, they go out to dinner with their spouses, and their conversation turns from national politics and children's activities to the recent renovations of the beautiful State University new Student Center. Is this conversation a violation of the Open Meetings Act? Anybody want to weigh in? So no, there's only 2 of them, so there's not a majority of a quorum here. Obviously, be cautious. You're out, you're out for a nice evening. If people recognize you, you may not want to be discussing public business. But certainly a conversation about renovations of the Student Center between 2 of them is not a problem. What if board member Paul Plain is at the same restaurant and joins the conversation? So then we have a problem, right? So then we have 3 members, and this is where you really want to start being cautious, and obviously you can't have this. If there was a Buildings and Grounds Board Committee made up of board members, these 3 board members, does that change the analysis? Anybody want to weigh in?
If it's 3, it falls under the Open Meetings Act.
Right. Yeah. I mean, it's the same analysis, right? It's the same 3. One thing I just like to note about, thank you, Polly, for weighing in. The one thing I do want to note about the committees is that the committees themselves are looked at not based on the full board, but on the size of the committee. So if there were only 3 members of this committee, then 2 would be a majority of a quorum, would be a majority of the committee and a majority of the quorum. And so even 2 of them discussing this would run afoul of the open meeting. All good? All right. Okay. On a separate matter, board member Handsome learns from the college's university's architect that Shady Builders, the university's construction company, for the recent renovation project, may be filing a lawsuit against the university for lack of payment. The board's agenda did not include litigation under closed session, and the board did not mention litigation in its original motion to go into closed session. Can the board discuss this possible litigation during closed session? Right, so I think Karen's shaking her head no, that's correct. So what they would do in this circumstance is they would go out into open session and they would make a new motion to go into closed about litigation, and then they could go back in to discuss litigation. But I do want to caution about the litigation exception. Obviously, you can go into closed session if you have an actual piece of litigation pending, right? That's clear, crystal clear. The issue of whether something is a possible piece of litigation, so the actual language from the law is probable and imminent. And so, we would have to sort of really dig here or question here whether just sort of, if you learn from an architect about, you'd want to drill down as to how real or probable or imminent this threat is. because what you actually have to do in closed session is you need to have someone record in the closed session recording the basis for finding that the litigation is probable and imminent. Okay, so you could, someone would say, well, I talked to the architect who actually was talking to the head, the CEO of Shady Builders, and he said, I am going to sue. You know, those kinds of things. You know, we'd have to think about, you know, how much you need to put in, but you do need to record that so that it's clear why you were able to talk about this potential threat of litigation in closed session. Okay. On the first day of winter break for beautiful State University, a local citizen, irritating Iris, emails the chair on the chair's personal email requesting the resumes of the presidential candidates and all emails of trustees discussing the candidates for the position. Is this a proper FOIA request? So, yes, it is. I mean, you know, ideally people, you know, request documents from the FOIA officer, but any request that comes in like this is going to constitute a FOIA request. And what the Board of Trustees, the chair in this case, or any Board of Trustees that gets a document request in, is that they should immediately refer it to the FOIA officer. You know, there's a very tight timeline on FOIAs, as you all know. And so you want to make sure that you get it to the FOIA officer, but we would consider this a proper FOIA request. So you should, in fact, respond and report this as at your board or on your board report or on your FOIA report. In terms of the response itself, you know, again, it depends. There may be some exemptions here to some of these documents. There may be some redactions that can occur to the personal information on things like resumes. So, you know, your FOIA officer would then take care of looking through these documents to make sure that if there's an exemption that applies, that it is applied to these documents. Okay, I am going to pause here and see if anybody has any final questions before we move on to the topic of the Meetings Act and the FOIA law.
Nikki, can I just ask a quick question on the FOIA issue, or maybe look for a little clarification?
Sure.
Liz is our FOIA officer. So what I would suggest, and check me on whether or not this is a correct statement, is that if any of our board members get a request for a document or information, that should just be forwarded directly to Liz, and then she will take care of responding on behalf of the university.
And
Yes,
that's what
absolutely.
normally happens.
Yeah.
They're very good about that.
Great. Just wanted
Yeah,
to
that's good.
clarify that
Trustees,
point. Thank you.
No, thank you for that clarification. Absolutely. So, the document should definitely, the email, the request, whatever it is, go directly to Liz. Trustees should not engage and respond because there's a process that your FOIA officer, Liz, will go through to respond. So absolutely. One less thing that you have to do. All right, good. And Polly, I don't know, I'm gonna go through ethics next, and then just let me know in terms of breaks or timelines how you wanna run this, okay?
Let's go about every 90 minutes or so and then take a break.
Okay, so you'll let me know where we're at, right? Because I think we're around 45 or 50.
Yeah.
Yeah, time for a break.
Hey, Mark.
Hey, Mark.
Good morning.
All right, so why don't I do this? Polly, I'm gonna go through ethics and then I'll just check in with you again since I think you're probably watching the time a little bit more closely than I am. Okay, I wanna talk about ethics in general for board members, for trustees. We'll talk about conflicts of interest. We'll talk about financial conflicts. We'll talk about some statutory ethics act issues. Again, a lot of this is going to be things that you know or are intuitive or you've read in your board documents. Some of this exists within your bylaws and your regulations, but I think it's important to sort of run through it and think through it so that you don't, and you know, you always should utilize Liz and your university resources if, I'm sort of a when in doubt in terms of conflicts and ethics issues. Use the resources at your disposal to make sure that you are feeling comfortable with the positions that you're taking, or that you're, you're removing yourself from situations that could present a conflict. So let's start with conflicts of interest generally. When identifying whether a conflict of interest exists that impacts whether a trustee can make an independent decision about an issue, the trustee should think about identifying the conflict if there is one and how you manage that conflict. So a conflict of interest could arise, or it does arise, when a trustee has to make a decision where you're obligated to act in the best interest of the university, but you have at the same time a separate personal interest or a duty owed to a constituency that you feel is in conflict with the university. And ultimately your duty, and we're going to talk about duty and loyalty of care a little bit later, but your duty is ultimately to the Board of Trustees, to the university. So it's possible that there will come a time where you have a real conflict, or you have a potential conflict. And so if you believe you have any of those conflicts, you should disclose them immediately. It's really important that the board, an individual trustee member who believes that they have a conflict or a potential conflict, that they disclose that, because you want to avoid, sometimes a potential conflict doesn't come to fruition, but you want to avoid any appearance of conflicts, because the public confidence in the university is going to come down to, the integrity of individual trustees and how they conduct their business and how they manage the university. And is it solely for the benefit of the university, or are they acting on some other personal interest? And that could certainly undermine the reputation and the ability of the university to carry out its mission. Again, I would not stress enough that if you have a conflict that you believe is there, or you're managing a conflict, Liz and your legal advisors are important to figure out what is there a conflict? Is it something that you need to? Is there a vote that you need to recuse yourself from? Is there some issue that prevents you from acting as a board member in a certain circumstance, or is there something else going on? Because a decision ultimately that you take, if you have a real conflict, could be invalidated if you didn't take the proper steps of disclosure and managing that conflict. So what am I talking about? Some specifics. So, personal and financial interests. So a trustee or their spouse or immediate family member can't have an interest in a financial or personal interest in any of the contracts or business operations that affect or appear to affect your independence as a trustee. And we'll talk about contracts later and the specifics about, there's a number of state laws here that are overlapping that we'll talk about. But if it's going to affect your objectivity, your loyalty to the university in any way, if your financial interest, then you cannot have such a conflict. So again, some conflicts that could come up are like, if you're referring a vendor to the university for a specific transaction without board approval, or you're engaging in outside employment with a university vendor that's not disclosed and not proper, or you're using your prestige as a trustee to encourage the hiring of family members at a vendor. So you're using your role as a trustee to get, someone in your family hired at an outside vendor. You're using your role as a trustee to gain any advantage in your private or personal life, or you're divulging either confidential or non-public information to other folks that are not authorized to receive it. That could potentially create a conflict. So again, most of these things you're never going to run afoul of, but if something comes up that you believe would present a conflict to the university, your relationship with a vendor, your family member's relationship, your interest in a contract, all of those things. Some of them are going to prohibit you from acting, and some of them are going to be more impactful in your role as a trustee. Make sure you're reaching out to the university's legal advisors and making sure that you are not running afoul. So again, I think a lot of that is well known to all of you. I do want to talk about a couple of other ethical issues that you need to keep in mind as trustees that are governed specifically by state law. The first is the Illinois State Officials and Employees Ethics Act. And this act has a number of components, but I do want to touch on two of the major prohibitions that you need to keep in mind as trustees. We are entering, obviously, or we have fully entered, I should say, the political season here, the national political season, and you do need to keep in mind that there are very strict prohibitions on political activity in conjunction with your role as a public university trustee. So first, under the Act, the definition of a prohibited political activity, it's hard to say that, includes any activities that are in support of or in connection with a campaign for public or elected office, any political organization, and any activities that are in support or opposition to a referendum question, anything that's going to appear on the ballot is going to be prohibited political activity. Important to note is that there's no exception for de minimis use. So you send a couple of emails with your university email address to a friend about a political campaign, and that is in violation of the Ethics Act, even though it's just a couple of emails. You cannot use any university resources to engage in political activity. So you can't do it during, obviously for your employees, for the employees of the university, they can't do it during work time. Obviously they can do it on their own personal time. And they can't use any university property or resources, and that goes for trustees as well. It's also illegal for you all to, misappropriate the use of employees by requiring them to perform any prohibited political activity. So you cannot direct an employee to support a political campaign or send out leaflets for the campaign as part of their job duties or as a condition of their employment. If you really shouldn't be doing it at all in general, like even if you have a private relationship with an employee of the university, I think I would exercise some significant caution in terms of asking them to do work on your behalf. So again, soliciting campaign contributions, assisting at the polls, circulating petitions, hosting rallies for candidates. I'm not suggesting that as university trustees, you can't do those activities. You just have to be very clear that you're not doing them in your official role as trustees, and you're certainly not using any university resources, and that includes university personnel, to carry out any of those political activities. And this I should mention, and we'll talk about board policy in a minute, but you also have a board policy on political activities, which governs your employees as well as your trustees, that is similar in terms of it runs through these prohibitions as well. Again, super important to keep in mind, particularly now as national politics are sort of on everybody's mind. The other piece of the Ethics Act that I want to stress is the gift ban. So no trustee can intentionally solicit or accept any gifts from any prohibited source. This includes, like, your spouses can't receive them, or your immediate family members can't receive them either. What is a prohibited source? So a prohibited source are people or businesses that do business or seek to do business with the university. Folks who conduct activities that are regulated by the university in any way, folks who have an interest that may be in any way substantially impacted by the university's official duties, or anybody who is registered or should be registered as a lobbyist. So there are a number of exceptions to the gift ban that I'll go over, but when in doubt, if you receive a gift from a source that you believe might be a prohibited source, talk to Liz, talk to the administration, because we don't want you in a situation where you've run afoul of the Gift Ban Act, because, this is obviously a serious issue. And I'll talk a minute about a violation that did occur at a university recently, not too long ago. So again, there are some exceptions to this. If you are offered something that is offered to the general public, so there's a discount that a vendor of the university offers, but it's offered to everybody who walks in the store, you can take advantage of that. That doesn't run afoul of the gift ban. If you receive a gift, we often joke, like if someone just drops something off at your house and you are unable to return it, if you make a contribution to a charitable organization in the same value, so someone gives you a gift basket of food that's over $100, if you make a contribution to the Humane Society for $150, that will offset it. But again, you should discuss this with your legal counsel before you do so. If you have a gift that's given by a relative, if you're given a gift by a friend, but it's clear under the circumstances that the gift was given not because of your position at the university, but because of your friendship. Food not exceeding $75 and gifts for a calendar year totaling under 100. So again, if you get a gift and you have a question about whether it's proper or not, you should check, because obviously you don't want to run afoul of the gift ban. Again, I mentioned a violation. The OEIG at the University of Illinois at Chicago found in an investigation that one of the vendors of the university, called Midwest Food, actually gave gifts to the athletic director and other UIC employees and officials. There were tickets to the Bulls games, the White Sox games, use of an apartment in California. There was a number of gifts, obviously clearly above any value in the Gift Ban Act. And it was, they found significant violations because Midwest Foods was considered a prohibited source because it did business with the UIC, both with UIC, and also it was seeking to do additional business there. So again, when in doubt, refuse a gift, or check with Liz, but you do need to be cautious because, your acceptance of seemingly a benign gesture of goodwill or a nice gift could be seen as a quid pro quo. And obviously that's what the statute is ultimately looking to prevent, you guys ending up in a position where it looks like you've given out university business because of what you're receiving in return. So I mentioned board policy. Again, you do have board policy that touches on these issues. You have a conflict of interest policy. The trustees in particular are expected to refrain from entering into any activity that might constitute a conflict of interest with Western, or would in any way prejudice your ability to carry out your duties and responsibilities as a member of the Board of Trustees. Again, your board policy says very specifically that any situations in which a conflict of interest might exist or might appear to exist should be referred to the university and to the board's legal counsel or to your own personal attorney if that's something that you need to do. I want to stress what the language of your board policy, because it talks about a conflict that might appear to exist. And again, we talked about this a little bit at the beginning of the ethics presentation about a possible conflict. But as all of you, as Board of Trustee members of a major public university know, that optics are often 50%, if not more, of a situation. And so even if it doesn't end up being a real conflict, just the appearance of a conflict can greatly undermine the ability of a university to carry out its duties. And so again, I'm a big fan of when in doubt, make sure that you are checking. The other thing, I mentioned the fact that you have a university policy on political activity. You also have a university policy on gifts. So to the extent that you haven't read your policies in the last couple of weeks, if you want to take a peruse through them, maybe on the next beautiful Saturday, you can spend your time doing that. But I do, make sure you're familiar with those. If you have any questions about them after you read them, talk to Liz, talk to the administration. because you do want to have a significant comfort level with any of those policies that particularly are applicable to your role as a trustee. What I'll just say sort of in closing on ethics, and I don't want to hammer this point. I know that you guys all understand this, but good governance requires that you all are independent decision makers, and that you're acting when you're acting as a trustee, you're acting solely in the interest of WIU. And so, this is why it is so important that you both follow state law and you follow your board policies, and make sure that you're not running afoul of it, even in a way that wasn't malicious or willful. So again, knowledge is power in this certainly in this circumstance. So I'm happy to answer any questions, but if you have any on those issues.
Nikki, what were some of the consequences for all these violations that board members made for the board members personally?
Yeah, I mean, often what we'll see obviously is a board member being removed from the board. That is obviously a significant consequence. Sometimes there are financial restitutions that have to be made, particularly if the gifts, those are some significant consequences to the board members who have run afoul of some of these. There could be some other penalties that they're assessed, and so sort of depends on the nature of the violation, but you do need to be cautious. Okay. So we are going to talk about sort of board matters. This is probably the lengthiest of the sections. I think, Polly, if it makes sense and we're sort of in terms of timing, I think what I'm going to do is likely go through some of the statutory requirements, the sort of nuts and bolts of the board. And then before we get to the documents I was discussing, maybe we'll take a break then. That makes sense to everybody.
Good. Yeah.
I know that it's hard to sit and listen to me sort of groan, so I do want to be cautious of that. Okay, so I want to talk, I mean, a lot of this is going to be stuff that you guys know, but one of the requirements of the board leadership training is really to talk about public university law, particularly Western Illinois University law that applies to WIU. So I do want to make sure that we cover sort of the big ticket items that relate to the Board of Trustees. Obviously, there's lots of different statutory stuff that applies to the university that we will not exhaust, but I do want to make sure that we cover the big issues related to your board. So obviously, as you know, your board is created by statute. You're created under the Western Illinois University law, and you have the power to operate, manage, control, and maintain the university. So your membership, as you know, and as clear from the screen, is you have 7 voting members that are appointed by the governor and confirmed by the Senate. And you have 1 voting member who is a student who is chosen by a campus-wide election. The student's term is 1 year. There are a number of requirements in the statute itself related to what the student, the qualifications of the student. So the student member has to maintain a grade point average of at least 2.5. They have to be a full-time student. They have to be a resident of the state. And interestingly, they can vote on all matters except faculty tenure, faculty promotion, or any issue on which the student member has a direct conflict of interest. So that is your student member. The non-student members serve for 6-year terms. There's no more than 4 affiliated with the same political party. You all have to be residents of the state of Illinois. If at any point you lose residency of the state of Illinois, you can no longer serve on the Board of Trustees of a WIU. I know that you just went through your officer election last meeting, I believe. Again, they're elected annually pursuant to statute. And again, the officers specifically referenced by statute are a chair and a secretary elected by a secret ballot. There are a number of powers. Your power comes from the statutory provisions that are outlined in WIU's law. The specific powers of the board are set forth in section 35-45 of that act. I am not going to go through them all with you because it is a lengthy list, as you are no doubt aware. But I do want to highlight, some of your major both responsibilities and authorities. So you obviously, as you know, have authority to enter into contracts. We're going to talk about contracts a little bit later on in the day. You as a board can be sued, or you can sue someone else, or you can be sued. You can acquire property. You can expand the funds of the university through various revenue generating activities. You can make rules and bylaws for the management of the university, which you have in place. You can amend those rules and bylaws as well. You can employ and for good cause remove the president and all other employees of the university. You have the overall authority to prescribe the course of study at the university. You can issue diplomas and bestow degrees, which is probably your happiest power. And you can borrow money for the sake of the university. So again, there are a number of others that sort of either fall under that bucket or are separate. I'm not going to go through them all with you, but you have a number of authorities and powers. We're going to talk a little bit later about the difference between the board's role and the administration's role. But certainly, these are the sort of big ticket items that you all are responsible for carrying out on behalf of the university pursuant to statute. So statute provides us sort of one layer of information and structure for your board. The second source of information structure for your board is your bylaws, which are handle a number of different topics. Certainly they address meetings, so the quorum required for a meeting, which is consistent with the Open Meetings Act. The bylaws require you to hold a regular meeting at least once every quarter and at least one meeting in the Quad Cities. You can hold a special meeting on the vote of 3 of your trustees or at the call of the chair. There must be a communication to all members of the special meeting at least 5 days in advance. The requirement for agendas is set out in your bylaws. We're going to talk about rules after the break. The rules of order in your bylaws indicate that the board must conduct its business according to its rules, its policies, its regulations, its policies, or Robert's Rules of Order. And we'll talk a little bit about Robert's rules when we talk about the rules. It also, the bylaws require roll call votes for certain items. Voice votes are otherwise acceptable. It also, your bylaws specify that in the event of a tie vote on any matter, that the action item will fail. So if you have a 4-4 vote, the action fails. All stuff I think that you guys know, but again, very important to understand the sort of structure of where these rules exist and how they apply. And so again, we started with the statute. We're moving to the bylaws, and now there's also the board regulations. So the regulations talk further about your agenda. For example, that the creation of the agenda is done by the president of the university in collaboration with the board chair. Materials must be mailed out to board members at least 7 days in advance of the meeting. Public participation is allowed, obviously consistent with the Open Meetings Act, and recording of your meetings is allowed, also required under the Open Meetings Act. So again, there's sort of a hierarchy or a structured process in place for all of your action. The board does have the ability to amend the bylaws and the regulations if it so chooses. Obviously, you can't amend the statute except through action of the General Assembly. So, if you want a statutory change, you have to go to your legislators. Otherwise, the board does have the power through processes to change or amend its bylaws or regulations. Those are sort of my, that is sort of the structure of the way that your board operates from a nuts and bolts perspective. If anybody has any questions on that, I'm happy to answer them. I do want to turn now to
I have a question.
going through some of these ideas on rules and guidelines.
I have a question real quick. With the nature of ours being an 8-member board, is that intentional by the state of Illinois or just Western where you don't have an odd number that a vote would, ultimately fail from being a tie? I guess my question is, so are all Illinois universities an even number of board members?
Yeah, Liz, I don't know if you know the answer for the other universities. I was somewhat surprised when I saw Westerns. I do think it is unusual to have an 8-member board. Certainly, we don't see that in a lot of other boards. So, Liz, I don't know if you know of the other universities.
I know some of them, but most of them are still even numbered boards, I believe.
I checked one time and I didn't look at every university, but I maybe 5 I looked at, and they were all just like ours, structured, and the statute was pretty much identical.
Okay.
I have a question too, for Nikki or Liz. You mentioned, we all know that the 7 members are appointed by the governor and then confirmed by the Senate. Is there a statutory time limit by which, if the Senate does not take action, that you are then automatically confirmed, or are you in limbo regardless of how long that process takes?
I apologize to all of you. My computer is doing some strange things at the moment. Could I just pause for a moment? Dr. Toomey, I got your question, but if I could just pause for a moment and then I will come back to that.
Sure.
Nikki, do you want to take a break and come back?
Yeah, let's do that. I apologize. Let me take a break. I just need to get my system back up and running, and then I can answer Dr. Toomey's question.
Okay, we'll take 15 minutes. How's that?
Perfect. Thanks so much.
Yeah, it's good. Good as you said.
I wanted to go back to Karen's question because I didn't quite hear whether there was an answer about the 8-member board. I was just taking a quick look at some of the others. All the state universities seem to have a different number of board members, which is interesting. So U of I has 12. Northern has a different number. Eastern has 9. Eastern has the same as Western. I will say that I find it somewhat unusual that a board would have 8 members. It obviously creates some difficulty when you have, a tie vote. So, but obviously that is a statutory requirement, and so if to be changed, it would have to be changed by the Illinois General Assembly. But it doesn't appear there's any consistency with which the state universities, at least in terms of the size of their board. So I apologize, I couldn't quite hear the answer if that was answered. I know for Dr. Toomey's question, it's a little bit complicated, and so what's that?
So it's actually in the Illinois Constitution underneath the governor's appointing power. So the Senate, within 60 session days after receipt, shall be deemed to have received advice and consent of the Senate. It's not exactly that clear. And session days, actually, Jeanette Malafa and I actually talked earlier this week. By our count, we still have until spring session of 21. So we're still a ways out due to COVID. Usually we would have had them by now, those session days, but they have not been completed yet.
Yeah, perfect. So again, there's an intersection of statute here and obviously a COVID situation. So thank you, Liz. I know that this has been complicated for boards because of the delay and also the fact that the General Assembly did not meet as typical, in spring session, in winter and spring session. So thank you, Liz. Okay, I am going to attempt to share my screen. I'm going to make sure that the right document is up first. Hang on just a second. So one of the things that I wanted to talk with the board about is right now, your board meetings are governed by, obviously your bylaws and your rules, but they're also governed by Robert's Rules of Order. Obviously, this is not unusual for boards, but boards often use Robert's Rules. I'm not a huge fan of Robert's Rules, and in large part, it's because they're complicated, right? They're long, and I think they are, they put at a disadvantage those who have not sort of spent a lot of time studying them. And they can seem, particularly both internally to trustees, but also to the public, they can create a layer of confusion and ambiguity that I think can sometimes work to the detriment of the board trying to conduct public business. Now, I'm not suggesting that you jettison Robert Rules, but I am suggesting that one of the things that I think about when I think about effective board meeting practice is I think about one of the key components is making sure that the meetings run efficiently. They are clear to the members of the trustees and the members of the public what is going on. And that I think, and this is, I think, particularly crucial, is that everybody on the board, all of the trustees, have an opportunity to be heard, but heard in a way that is effective for both robust but sort of discussion that actually is productive and leads to resolution of an issue. And obviously there are routine motions and routine items that you all vote on and do seamlessly. But I think, the rubber meets the road where you have more complicated issues, and discussion can prove to be unwieldy sometimes or unproductive if it's not sort of channeled in the right way. Now, all boards have these issues of how to structure conversation at the board level, how to talk about things in a way that, again, is efficient and productive at the same time, and where people feel like their points and their viewpoints are being heard. It is, and boards go through periods of time where they have very routine issues and periods of time where they have really complicated issues. And you want to be sort of prepared for both. One of the things that I did, or we think about as a firm, we represent a lot of public boards that have really complicated both internal issues and external issues, right? So issues that they're dealing with the public, but also inter-board issues. So, you know, all boards are different, all have a different personality and dynamic. But one of the things that we have been thinking about over time at our firm is, you know, how do you make board meetings better for the members themselves and for the public from a rule perspective? Look, I'm not going to come in here and tell you that I can make all of your, you know, whatever I don't go into boards and say I can solve your interpersonal, you know, communication issues. I'm not someone who's going to sit down and mediate your feelings. I don't do trust falls, but I talk about rules, right? Rules and structures can sometimes be the difference between a board that is, you know, where everybody feels like the board meetings are productive and really robust in their discussions, and meetings where people feel a level of frustration. So one of the things that we've done is we've created sort of rules of order in large part to replace the Roberts rules. Now, again, I'm not suggesting that you have to do this. I'm just gonna go through our draft of these with the idea that they might give you some things to think about. I'd love to have some conversation about this because I think it'd be interesting to talk through. I'm going to have, Liz, if you don't mind, I don't have everybody, all the trustees' emails. I'm going to put on the screen so everybody can see them. But to the extent that you could email out the drafts that I provided to everybody, so if it's easier for you all to just pull them up on your computer. So,
I can do that.
thank you, Liz. I appreciate it. Okay, I'm going to ask you just to confirm, Polly, can you see now the rules of order for discussion?
Not yet.
Not yet?
No, there, it just came up.
Okay, and it says rules of order for discussion.
Just lost it.
Yeah. Yeah, we can see that. It would be better if it was bigger.
Bigger. Okay, that I can do. Let's see if I can take it big off. Whoa. Is that better?
That's better.
That's better. Okay, good. It's very large on my screen now, so hopefully you can see it. And again, Liz is going to email that out so you guys can all have it in your computers if that's easier. So one of the things that I wish I had an actual copy of Robert's Rules to hold up to you guys, but it's big, right? So these are 4 pages. And again, I like that because I am contrary to many attorneys, I like less words. As not evidenced as by this training, but I generally like less words because I do think that it's more accessible for everybody to be able to like whip out 4 pages and understand how things are going to go at a meeting than to try to sort of sort through. Like I have, you know, I understand Robert's Rules, but it's not always intuitive. So again, I'm going to go through these. I would love to sort of stop and talk with everybody at points. Again, you know, it's just something to think about in terms of whether this might make some difference to you. Again, if you guys are like, Nikki, this doesn't make any sense to us, by all means, you can ignore. But again, some food for thought here. So the introduction of these rules, and I'm gonna go through each of these provisions one by one because I think it's important to understand the structure. What these rules are designed to do is 2 things primarily. The first is limit the number of motions that can be made. And how those motions are handled. And the second is to routinize how discussion runs on action items. So the first thing is, in the introduction, the first A is that these rules exclusively govern the discussion and action by the board, except to the extent that you have a statutory or agency regulation or order that provides to the contrary. So if there's a specific statutory provision that requires, say, a supermajority vote or the like, that would control. There are no other rules such as Robert's Rules of Order which apply. The reason we put that in is just to make clear that we're not going to be going back and forth between multiple kinds of board rules. Any questions with regard to the interpretation or application of these rules will be determined by the chair of the board. The term chair in these rules and throughout these rules includes the vice chair in the absence of the chair. I should mention, I think I mentioned this before, but in order to adopt these rules, you would have to actually amend your regulations, which require the Roberts Rules of Order. Any determination by the chair of the board regarding the interpretation may be reversed or modified by a motion adopted at the meeting in which the chair's determination is made. Any such motion must be made promptly following the chair's determination. Discussion on any such motion is limited to 1 round per trustee unless discussion is extended by the chair. So the goal of this B essentially is that if there's a question about the interpretation of the rules, that the chair or the vice chair, if the vice chair is serving the absence of the chair, will interpret. You could, a member of the board may seek to reverse or modify that ruling if a proper motion with discussion is brought. Again, our hope is that these are clear enough that such issues will not arise, but there's an internal mechanism to these rules to if there is a question about the rules. So that's really the basis of that. All right, this is where I want to sort of get some thoughts from the board, if you're interested in talking. So what we've done is we've basically said that there are 6 motions which could be made under these rules. To take an action on the agenda item, to reconsider action taken at the same meeting, and there's specific parameters around this that we can talk about later, to rescind or modify action taken at an earlier meeting, to place an item on the agenda for a future meeting, to extend the time for discussion, to close discussion, or to reverse or modify the rules of the chair on interpretation or application of these rules, which is what we just talked about. So it then goes on to say the motions 5 or 6. So to extend the discussion or close discussion will take precedence, and motion 7 takes precedence over all other motions. So the idea again here is to simplify the kinds of motions that the board can act on. One thing that you will not see in these rules, which I should highlight, is a motion to amend. You cannot amend a motion under these rules. The idea is that you either have to defeat the motion. So a motion, if a motion is made, you either have to vote it down, you have to revise, you have to you have to make a new motion, or you can ask someone to withdraw a motion. But the idea that you'll reduce the friction if you don't allow people to seek to amend motions from other board members. So that's the idea behind that is one of the ideas behind the limitations of the motions. So I'm happy to answer any questions or get any thoughts from folks about this. Again, just move them up again. Again, just trying to streamline process.
So I have a question. Are you specifically for us, or this is something that you always do?
So, we created these not specifically for WIU. We created these about a year ago internally at the firm when we were thinking through issues that we see some of our public boards grapple with in terms of process and motion process in particular. And it got us to sort of thinking about the idea of streamlining the rules for board meetings, but particularly around the issue of motion practice. And so, again, I adapted these so they read about WIU so that you could, digest them. But we had created them about a year ago, like I said, because of, again, every board has a different sort of personality and a different flavor. But we saw some boards, struggling with, not so much struggling, but just sort of dealing with the ramifications of how their motion practice was working. And again, just a goal of sort of getting things going for the simple rather than the complicated.
I've operated under Robert's rules, Nikki, so I really like this format. This is a one-pager that board members could have in front of them at all board members and just help guide the process while that part of the process is occurring. So I really like it. It's simple, it's easy to understand, and I do think it provides some structure in that discussion part of a meeting.
Okay, great. I'll keep going. And if other people have comments either about that or more of the other things, again, my goal here is to get you guys thinking about this. I'm not expecting anybody to be like, let's adopt these tomorrow, but it's something that you guys have at your disposal. So again,
Nick, can you talk a little bit more about the no longer being able to amend, because we have done a lot of amending as a board. So I just want to understand. It basically you're just starting over. Then you don't amend the motion that's on the table.
correct. That's right. So yeah, I mean, I think the idea is to, you know, if someone puts something on the table, you know, I think that how we originally sort of thought about this in some ways, and is that we had seen it with some other boards, and I have not watched your board meetings, so I can't speak to this, but that, you know, there were times where, and I don't want to say it, it sounds so awful to say it in this sort of language, but like board members were sort of hijacking other people's motions in essence. Like they were seeking to amend. One board member would make a motion, there would be amendments, and there was a level of confusion that created. Like, are we voting on the original motion? Are we voting on the amendment? Are we voting to amend the original motion, or are we actually adopting the amendment when we vote? And it ended up sort of elongating. And then the original person who made the motion was like, well, I don't want the amendment. So do we have to vote on whether it can be? I mean, it just creates this sort of cycle of, I think, confusion and anxiety amongst the board members. So the idea is you have to, if you don't like the motion that someone puts forward and you want a different motion, that you vote down that motion and you create a new motion. Now, I know one of the things that I was talking about briefly with Dr. Abraham ahead of time was, you know, what happens if, you know, there's a resolution and, you know, what happens if you just want to sort of change the drafting of it? Like there's something about it that you just don't like. You know, you can always withdraw a motion, revise the resolution itself, and then make a new motion. The other option in that circumstance is just to present, like if the administration drafts a resolution and the trustees are just concerned about the language itself of the resolution, you know, you can discuss the resolution before making a motion. You can then, you know, revise the resolution itself, and then make a motion to adopt the revised resolution. And so, again, the idea here is just to try to prevent that sort of round and round and round we go, and just, you know, have folks act on the motion on the table.
So Nikki, just to a point of clarification, if I make a motion at a board meeting and through the discussion phase, it's clear to me that motion's not going to pass, rather than going through the whole voting process and then somebody else make a new motion, at that point, I could just withdraw my motion.
Correct.
Yeah.
Correct. Okay, I'll keep going. And again, you guys, whenever you want to stop or go back, I'm more than happy.
So Nikki, just before you move forward, one of the problems we've had on our board is that a motion will be on the table and we're having discussion of the motion. And then someone will disagree with some component of the motion. And they'll offer an amendment to the motion and the amendment won't pass. So that person who offers the different point of view often feels that she or he is not heard, or that the board is not acting on their particular idea. So with this plan, we just get rid of that original motion, and then we come up with something new. And that at that point, that trustee would have an opportunity to interject his or her new idea. Is that
right? I mean,
reasonable?
Yeah, that's correct. I mean, the idea is that if someone makes a motion and people are unhappy with it, it gets voted down, and then there's an opportunity for a new motion to be made that would have, for example, the amendment that the other board member or the trustee would like to see. again, we'll talk about the discussion part of this, which might help as well. But the idea is that everybody understands that this is how it goes. Like, you have to take action on an item, you have to vote it yes or no, or as Dr. Toomey suggested, someone sort of sees this isn't where we're going and I want to withdraw it. And then a brand new motion gets placed on the table that then has the same process.
Okay, so I think just from a clarity standpoint, then Nikki, I believe what you're saying, that each motion stands alone. We don't muddy it with a lot of different amendments. That way that we take away any confusion, but in no way does it minimize or prevent us from putting new ideas or anything on the table that we think is for the university.
Right, absolutely, absolutely. And that's absolutely correct. And people should be very clear in, we'll talk about the discussion. If there's something that folks want to put on the table, there's always an opportunity to do that. It just, the only thing that's removed is this idea of amending motions. But it in no way precludes what you're suggesting, which is getting things on the table that are beneficial to the university.
Okay, I'm comfortable with it. Thank you.
Sure. Again, any trustee may raise a question at any time as to whether trustee compliance with these. We're going to talk about the communication and meeting guidelines next, or the bylaws or regulations. That's just, again, not necessary for these rules, but just, again, to raise questions about how trustees are complying with their own rules and bylaws.
Nikki, before you go to two, because this is really a big deal for our board and how we've been conducting business, this section 1.
Okay.
And so I just want to make one other point for the other trustees to consider is when somebody makes a motion, even if it passes, because if I'm not willing to take my motion off the table and I want to go for a vote and it passes, it's not that those other board members can't be heard, because once they make another motion, I just want to remind them, number 3, we can always go back and rescind the action taken earlier if there's a better idea, for lack of better words, that hits the table.
Yeah, absolutely. I mean, the idea is that obviously boards, situations will grow and evolve, things will change. And so if there's action that's taken at a previous meeting that, needs to be amended as things play out, I mean, obviously we all act in our best interest and understanding the best interest of the university and our understanding of the dynamics on the ground. We'll talk a little bit about duty of care and duty of loyalty later. But, situations are fluid and not everything ends up the way that you think it's going to end up. And obviously boards are always going to want to be able to rescind or modify action taken at a later meeting. If it's not running the way that they had expected, or they see an opportunity to make improvements.
And I'm sorry, I should have said number 2, reconsider action at the same meeting, meaning that my motion gets passed and somebody else then can speak their piece and put their motion on there. We can always go back and change the action that just occurred.
Yeah, although yes, that is correct. I just scroll down because I do want to say that one of the other things, again, these can be modified in whatever way you choose if you ultimately end up deciding to go in this kind of direction, is, once a motion is adopted, the substance of the action approved by such a motion may be reconsidered at the same meeting only through a motion for reconsideration made by a trustee who voted in favor of the motion to be reconsidered. Reconsideration is available only at the meeting in which the action to be reconsidered was taken.
Oh, excellent.
So the reason that we include that is that the idea is that if, let's say, one of the trustees makes a motion and you vote in favor of it, and you decide later, I think it could be, we should reconsider that, then you can go back and do that. What we're not trying to do, though, because it would then just undermine the lack of amendment, is to have a trustee who voted against it, who sort of lost the motion, to be able to go back and just seek reconsideration. Because again, the idea is that the board votes, right? Ultimately it acts, and it's a majority, most of the time it's a majority rule. And so if someone later in the meeting who voted for it, including the person who made the motion originally, says, you know what, I'm now that we've talked about 6 other issues, I'd like to go back and reconsider what we did, then you can go ahead and do so. But it can't be a mechanism by which the board members in the minority go back and start to elongate the meeting by seeking more and more votes on the same issue.
That makes sense. Thank you for the clarification.
Yep. Again, and then F just sort of reinforces the same point that I was making on number 3, which is once a motion is adopted, the action may be rescinded or modified at any later board meeting through the typical process to make a motion. So obviously, again, there is some significant difference probably in the way that your action and your motion practice is working right now. So it's certainly something to think about and consider when, but again, the idea is to try to clarify and streamline the motion making process also for the people that watch your board meetings that may not, have had the kind of interaction with Robert's rules that, and it can feel, I think I've watched a lot of board meetings over the years, and sometimes it can feel as people are not being heard or not being understood. And again, trying to sort of reduce that occurrence as much as we can. Okay, I want to talk about the discussion part of this. To me, this is sort of also just, if not as critical, more critical than the motion practice itself, because I'm a really big fan, again, of structure. So structure is consistent and people understand what to expect. And it also just, it provides guideposts, right, for us. So we know how to sort of engage on an issue in a way that's productive. Okay, so discussion on any matter at a board meeting must be germane to an item on the agenda for the meeting or otherwise properly raised for discussion at the appropriate place on the agenda. So as you all know, you can not act on something that's not on your agenda, but you can discuss it. But it has to be, raised as a discussion item and placed on the agenda as a discussion item. So the idea again that we don't just have free-flowing discussions at board meetings. That the discussion is specific to the agenda. Again, not to try to curtail discussion, but just try to make it sort of streamlined. Okay, so this is really the heart of it though. For meeting effectiveness, discussion on each agenda item will proceed in at least 2 rounds. During the first round, each trustee will be given the opportunity to present his or her views and pose questions to the administration or other trustees. Second round, each trustee will be provided the opportunity to reply to questions and comments from other trustees. Unless otherwise provided for in the agenda, each trustee will have up to 3 minutes in the first round and 2 minutes in the second round to speak.
Nikki, you're freezing up.
So that is sort of the heart of agenda item discussion.
Kind of breaking up and can't hear.
Nikki, could you go back and do that one again? Yeah.
Yeah, you need to go back to 2.
Okay.
You're frozen.
Okay. Okay.
Now we can hear you.
Okay, great. So, I don't know. Still see my screen?
Yes.
Okay, great. Do you want me to go through that again?
Yes.
Okay. Apologies.
Yes, please.
Okay, I'm so sorry, guys. Okay, so again, for each discussion on an agenda item will proceed in at least 2 rounds. During the first round, each trustee will be provided an opportunity to present his or her views and pose questions to the administration and other trustees. During the second round, each trustee will be provided the opportunity to reply to those questions and comments and make any additional statements that they want. In each round, the president will be provided an opportunity to present his or her views and pose questions to the trustees or other administrators as needed. Unless otherwise provided for in the agenda, each trustee will have up to 3 minutes in the first round and 2 minutes in the second round to speak. Obviously, again, if there's an agenda item that is complex that you want to allow more time, you can certainly do that. And you can designate it as such, but the idea is to try to keep the discussion.
After point 4.
I'm gonna ask a question. I'm sorry, Polly, can you ask that again?
We lost you. We got through point 4, and then we lost everything after that.
That was it, just to point 4. I opened it up for question at that point.
Is the intent of this more or be more conscious of our time? Or is this with the timer?
I'm sorry, I got a little of that. Was the idea behind this to try to like I'm sorry, to limit the time? Is that what you had asked?
Yeah, I said, is the intent of this, as you set up in the beginning of it, for meeting effectiveness, and just to be respectful of one another's time? Or is this an official thing that we now have to sit there with a timer and be like by the book monitoring our times? I just want to understand how this is to be used.
Yeah, absolutely. So the idea behind this is to, I wouldn't say it's to sort of limit the time. I think the idea is to make sure that everybody gets a turn in terms of each trustee gets to offer their views, in 2 different rounds, so that everybody feels like they have an opportunity to be heard on an issue. It is also designed to not allow discussion to get away from itself in terms of just sort of endless rounds and rounds and rounds we go. I'm not suggesting that you hold a timer, but I think the idea is that board members will be cognizant of the fact that that their time is limited and that they should make their comments in a succinct manner. I mean, you don't have to keep 3 minutes and 2 minutes. You don't have to keep specific time. You could, in fact, just suggest that trustees will have a limited time each time, or will present their time in a concise manner. But the idea is to routinize discussion in a way that actually enables people to speak, to stay on topic, and to respond to the issues that are raised in a way that's productive.
I think this very specific thing too, as a group, will help us build more positive relationships. Because if we know, I mean, we all know, right? We've had questions that we've discussed for 2 hours before we get to a place where we can discuss, where we can vote. And I think this just kind of helps us set some guidelines for all of us. That you all know I like to talk. And so I just think this helps provide some guidelines for us that, as Nikki said, it ensures that everybody gets an opportunity. And if I don't have much to say, I don't take my 3 minutes. I pass my time on to the next person, or not my time, but my turn on to the next trustee.
Yeah, and there is a mechanism to formally do, like, you can certainly just pass your time, absolutely. There's also a mechanism by which someone can forgo or allocate to another trustee all or any portion of their discussion time. And so, for example, if there is a motion on the table at which that a trustee has the same views or has actually done more substantial investigation into the issue, and you want to allow them to take your time, you can certainly do that. Or you can just forgo it.
In the boardroom be muted because it's hard for us to hear.
Can you hear me now? I'm sorry. I know that this is not the greatest sound quality right now.
So do we have anything from trustees who haven't weighed in on this? Eric or Doug, Greg, Justin?
I'll weigh in. Excuse me. I think that, obviously from a communication standpoint and streamlining communication and just making sure that every voice is heard equally and fairly. I think having that structure in place, like Dr. Toomey mentioned, having that opportunity, and some trustees may not have as much to weigh in, but at least that platform, that structure is there. I think that's going to be a key component as we move forward as a board, that we have that opportunity. And, if you don't have much to weigh in on any particular topic, you don't give up your time, but you can roll it over to the next trustee. So I think communication, if people have learned to know me and are learning me, it's all about communication. We've got to continue to communicate as a board. That will be the key to our success. I believe at day one, minute one, and as we go forward over the next days, weeks, and months, we've got to continue to communicate. This will help in that process.
I think this will be good from a debate standpoint. Just limiting a mechanism to limit discussion on items where I think we have the same issue in Peoria on the school board. We don't have a mechanism like this, and our meetings can go 5 hours from, on a controversial topic, where I think we get to a point where we are where we are. We're ready to vote, but we're still debating this and debating it, but there's no structure in place saying that we're going to limit the time, and we end up talking all night. So I think we should have this here, and I also would like to look at bringing it back home. So, yeah.
Greg, Justin, do you have any comments on this?
Greg has 2 thumbs up.
Okay, I'll continue through some of these other stuff things we can discuss, and then I will leave this document with you. And again, happy to have you take it, use it, adopt it, or amend it. I'm happy to weigh in and help you through that process. So see, this sort of limits, again, discussion on non-agenda items that can come up, limited to 1 or 2 rounds, as set by the chair, and the president given an opportunity as well. D just discusses a rotational method being administered so that, sometimes, the order in which the trustee is afforded the opportunity to participate. Again, E we discussed. Additional time for discussion may be allowed at the discretion of the chair, with each trustee, again, limited to approximately equal time set by the president. Again, an adoption of motion, there can also be a motion to allow additional time. Again, discussion on such motion is limited to 1 round. So if there is sort of a meaty topic where a board member would like, they could make a motion to have an additional round of discussion. Once discussion has been done, that's it, as we've discussed, it's the close of the discussion and a call for a pending motion vote. Okay. So this part of the rules is really just sort of more of the nuts and bolts of voting. I don't know that there'll be much to discuss here, but I do want to go through it. Action is initiated by a motion, as we've talked. A second is required. Originally, we had suggested, we actually had removed the idea of a second. Boards seem to really like seconds, so we have concluded a second. Obviously, that's not something that's legally required, but something that we've included in here. Repetitive motions of the same substance are not permitted. So we're not going to start. I understand that you have a 4-4 vote board. We're not going to go over and over again on the same motion. Once a motion is made, discussion of the motion, again, we'll go through the discussion as we set forth above. And then amendment, here, this is more of the specifics. Amendment of the motion is not permitted. If a motion needs to be changed, the motion must either be withdrawn, which we talked about, with a new motion made in its place, or voted upon and defeated, followed by a new motion. This, I think, is consistent probably with your understanding of Robert's rule. A motion passes if it receives a yes vote of the majority of those trustees actually voting yes or no, unless again, there are some very specific statutory requirements of you need more than a majority. A motion fails, as I think you guys well know, if it receives an equal number of yes or no votes or a majority of no votes, unless a different result is required by law, so a tie or a vote down. A trustee who responds to a call for a vote on a motion with an abstain, present, or pass, or similar response will be shown in the minutes to have so voted, but will not be considered to have actually voted for the purposes of determining the outcome of the vote, unless a different vote or result is required by law. So I think this is probably consistent with how you do it now, but obviously an abstention isn't counted for the purposes of the numbers when you're thinking about whether a vote passes or fails. Again, when a different vote or result is required by law, if there is something in the law related to abstention, the motion must receive the required number of yes votes in order to pass. And the Liz should be, in this case, should be consulted to determine the result of responses such as abstentions or present votes. When a roll call vote is required by law, which it is, and also under your bylaws, a rotational method of voting shall be administered, which may be the way that you do it as now as well. So those are just sort of the nuts and bolts of the voting process, probably pretty consistent with what you have now. Once again, we talked about E, once a motion is adopted, only someone who voted in favor is allowed to reconsider. And then F obviously allows you to go back if you need to at a later meeting to rescind or modify an action of the board. So again, the goal here is to make this sort of the opposite of rocket science, right? The very simple, very straightforward. These are for you guys, happy to, come back at a later date to talk about this further. If you guys are interested, Liz can certainly take you through the process of amending your regulations in order to adopt these. Or if you at any point want to sort of think through some changes to these, it's not, again, the goal of this is just to make you guys more productive. It's not to cast aspersions on the way that the meetings have been run thus far. Every board, has its ups and downs. And so every meeting has its own sort of flavor. But again, the goal is to try to make things as streamlined as possible. Okay, if there is no other questions or comments, I'm happy to come back to this document, but I'm gonna put up a different document right now, which I think is a little bit of a different idea. So just to give you a sense of where this came from, and then I'll put it up. I think Liz probably emailed this as well to you. This is more of a communication guidelines, meeting guidelines. So part of this was developed, I know, and I'm not going to speak for them, but I know the chair and the vice chair have been thinking through the idea of meeting norms and meeting guidelines, communication guidelines. A lot of boards adopt these, particularly when, and I know a lot of, I think most of the board is new, or like this, the configuration is new. So especially when there, there's new boards or newly constituted boards, meaning that there are new relationships in play, to try to normalize relationships and conduct at board meetings. By presenting these, there's no way, I'm not suggesting that you haven't been following these types of norms and guidelines. It's just sometimes really helpful to set them out on paper for board members to agree with. These are not short, and so we'll go through them. It's not that you have to adopt all of them. Like I said, the vice chair and the chair came up with some portions of this. Some of this comes from work that we have done internally, where again, we've seen that erring on the side of putting things out on paper can sometimes really help boards to think through, and sometimes making things super explicit is helpful. And some, to be frank, what is based on some of the discussion that I saw at your previous board meeting. So I think there's a combination here. I think you guys have, am I now sharing this is the trustees communication and meeting guidelines. All right, I'm gonna make it bigger, sorry. It's very small. Let me make it slightly smaller so you can see the words. Okay. So again, there's a lot in here. I'm not going to lie to you. This is a long document. There's a lot of meat to it, but there's, again, this is a draft document. It's not intended that you have to adopt it full cloth or adopt anything like it. But I think it's important to talk about this because it is important that I apologize if I'm getting this wrong. One of the trustees said at the last time that it is important to have healthy friction, I think was the phrase used during trustee meetings. So the idea is to sort of, again, set forth some norms of how this board is going to run. So again, in an effort to promote open, transparent, inclusive dialogue, these are the guidelines for conduct. So the first set is board meetings. Again, the rules are designed to help with this, but so are these norms. And I think that this is crucial. A lot of boards adopt statements like number 1, we agree to respect individual opinions. We recognize that disagreement, discussion, and debate are healthy components of deliberation. We pledge to conduct our discussions in a civil and respectful manner. When discussing matters at board meetings, we presume positive intent. And whenever possible, we will avoid using words and tone that imply that other trustee has done something wrong. I don't want to cut down disagreement. There's going to be disagreement. You guys are going to come at situations totally differently, but the idea is that we talk about it productively. I think that's fairly self-explanatory. We agree that all trustees should be given an opportunity to participate in discussions. There'll be no side conversations and no interrupting of other trustees during open and closed session. I think it is essential, especially the trustees who if they end up in a minority on a board vote, that they are not interrupted, that they get heard. The public deserves it, you all deserve it. So the board will rely on the chair to communicate with WIU administration on official business, but recognize the interests of individual trustees to communicate with administration on matters of concern or to ask questions that are pertinent to the university. If the administration communicates with an individual trustee, it will share the substance and response with the entire board of trustees. There's some more sort of communication guidelines, but the idea is that you should be able to reach out. I know that some of you are members of the community and such that you have a long-standing relationships with administrators and other folks, and you should have those conversations. But absolutely, and I would certainly encourage the folks that don't to develop those. But if there's a formal response to an individual trustee, as I'm sure it is now, the administration will respond to all of you. As individuals will be prepared for board meetings, obviously baseline, we expect that each trustee will have read the board agenda, any supplemental materials, any pertinent information before the meetings, and will be prepared to ask informed questions and vote when appropriate. I'm assuming that your materials are sometimes voluminous. I know that you all are volunteers to this position. I know that it's a lot of time and effort. The idea is just that, especially if you're going to limit discussion, that questions that are answered by the materials are reviewed in advance so that it doesn't, the time is not taken up on those kinds of matters. As trustees, we recognize that there are many sensitive matters about which the Board of Trustees must be informed, and that not all matters before the board should be discussed with employees, students, members of the community, or other state officials. We recognize that some matters before the board must be kept confidential, especially those matters discussed in closed session, and we pledge to maintain the required confidentiality at all times. This is a fairly common type of acknowledgement. We have had boards in the past that have had significant issues about confidential matters, particularly closed session matters being shared. It's very difficult to be issues, particularly the confidential items in closed session that pertain to individual students or individual employees, and that is of obviously paramount concern. I'm sorry, I'm going in and out again, aren't I?
Yes, you are.
Okay. I'm sorry. So you all can read those. I'm not going to put any more points on them. I'm happy to answer any questions about the board meeting provisions. Comments? Okay, I hope I didn't miss anybody. I apologize if I didn't hear. If I did, just shout out to me again. No, we're good. Okay, awesome. I'm sorry. Someday we will be in person and we will not have glitches in our computer systems. Okay, this is very structured. I'm not going to lie to you. I put a lot of structure into this. It may not be something you want to do, but here goes. Email communications. The chair of the board will send all written board information to all trustees in one email communication. So I'm just gonna, highlight the fact that the Open Meetings Act does allow the chair or the board president, for example, or Liz or whomever is communicating with you to communicate with you all at once at the same time. What we need to prevent is sort of, contemporaneous conversation. One email out to everybody is fine, and that's what's going to happen is one email. To avoid running afoul of the Open Meetings Act, any trustee wishing to respond or ask questions related to the information are encouraged to discuss the matter at a board meeting, but if more immediate communication is deemed necessary, we'll send a response solely to the chair of the board and the president. The goal of this, of course, is not to run afoul of the Open Meetings Act. Within a reasonable time frame, but no earlier than one business day and no later than 1 week after the initial informational email, the chair will send a follow-up email to all trustees, updating the initial information as needed. So the idea is that, let's say the chair sends out an email on a particular item, an individual board member responds with some questions or comments. Let's say 2 or 3 of them do. The chair will then send a follow-up email to all trustees identifying the questions or comments that the chair received and updating any information as needed. Okay. All communications shall be conducted with decorum and civility and with the understanding that such emails are subject to FOIA. Again, there may be some exceptions. You may not be releasing some of these, but they are all subject to FOIA. I realize this is very prescriptive. So again, just food for thought on, there were some things that seemed to be suggesting in terms of every board member getting the same level of information. And again, the idea is to routinize the information that's sent out. One way that you guys send out information is through email. So this pertains to emails. I'm going to keep going because there's text messages and telephone communications, and then maybe we can regroup and answer any questions or get any comments. Okay, text communications between trustees related to board matters shall be limited solely to scheduling. I'm like a really big fan of limiting text messages because I think they get you in trouble in terms of trying to release things after FOIA, under FOIA. And I really don't love the idea of substantive conversations happening over text for a couple of different reasons. Most is that it's hard to retrieve those texts if we need to. It also, I think people communicate informally over text, and I think that can lead to misunderstandings, or if we have to release text, then we have texts that have lots of, just sort of casual language that I think is not reflective of board members. Again, if you guys want to text about personal things, like I'm not gonna suggest otherwise, but this is just board matters. Again, you don't have to agree with these. This is sort of a framework. And the last is telephone communication. All telephone communications between the trustees obviously have to comply with Open Meetings Act. If the chair conveys substantive information or has a discussion with any trustee over the telephone, to the extent the information cannot be conveyed in a timely manner in a board meeting. So for example, if you have a board meeting the next day after having a conversation, by all means, just have the conversation at the board meeting. The ideal is always to have your conversations at the board meeting. But the chair shall provide the same information to all trustees through an email communication, or if telephone is required, a call to each trustee in turn. If the chair calls a trustee, except vacation or illness, you can add other exemptions if you want, the trustee shall return the phone call within 3 business days, or within 3 business days of their return from the exceptions. And vice versa, if a trustee calls the chair will return the call in the same time frame. this reduces the possibility of the idea of, I didn't get the call, or I didn't know you wanted to talk to me about that, or I didn't get the information, or I thought you didn't want to talk to me because you didn't get me a call back. Again, this is extremely prescriptive, so take it for what it is. And the last one is in-person communication. If you end up at that dinner party and you end up conveying substantive information, then the same information is then conveyed to all trustees through email or a telephone communication, or ideally, if possible, at the next board meeting. So there's an update to the building schedule on something, and the board sees a board member and says, "Oh, by the way, we're running ahead of schedule on the renovation to the student center." Then that, and let's say they have a meeting the next day, that is updated to all board members. If the meeting is not for another month, the board just sends out a quick email. By the way, we're running ahead of schedule on the student center renovations. Again, the idea is that everybody is getting information in the same way, ideally, if not within the same time frame. I am going to pause there. Okay. Again, food for thought. Okay. So then.
Hey, Nikki?
Yeah.
Hang on just a second.
Just one thing that I would like to see is something about the media, just communication with the media, maybe going through the communications director, or, because people on another board that I'm on have said some things that were not helpful. Board members have said some things to the media that were not helpful. So if they had gone through communications, it would have been better, or left that to the board president, vice president, or something like that.
I think that's a great addition. I think we should absolutely include that if you end up adopting something like this. There is a significant issue from a substantive standpoint when a board member is speaking on behalf of a board and is not authorized to do so by the board. If they're speaking on their own behalf, it gets very convoluted from a media perspective. So I think it's a great idea to channel all media requests, media communication to one place.
And Nikki, can you help us clarify something, or perhaps Polly or Doug yourself? I don't know if you mean the intent is outside of our board meeting days, or if you're including our board meeting days, because as everyone's aware, during our actual board meeting days, there's a tremendous amount of media in the room, and,
Right.
And quite often, based on how a person votes or what they say, as soon as the meeting's over, the media addresses many times a specific board member to get clarification on something they said or did. So are you suggesting that individual trustee should not respond to those media questions, or something else? I'm just trying to get some.
No. In fact, as far as a trustee's position on a vote, I would not want to put a muzzle on a trustee as I speak with a muzzle on. But no, if you voted on a position and they ask you about that position, you should speak on that. And it's your right, and you should be able to clarify. But outside of these board meetings, you know how the media will do. They'll try to, they'll go down the list until they catch somebody. And then, we have our media, our local media is we kind of train them to go through the communications director to even contact us first. They go through the communications director first, and they kind of shape the interview. What's it about? What are you going to do? That way the board member is not caught off guard by questions. They'll still do it from time to time. But at least they know somebody is looking at that interview, and they want to know what are you going to come at that board member with. So, but no. And at the end of the day, board members can still go out and say what they want to. But I think we should just this is kind of like a policy that we agree to, that hey, we're gonna channel our communications, and we're gonna speak with one voice as a board. So we're gonna push those communications to a central point.
Thanks for the clarification, Doug.
Yeah, one thing I will say though about, I don't disagree with the vice chair on, allowing folks to speak about the vote, but I would just remind folks that you act as a board, and although you may be in the minority of a vote, ultimately you have to abide by, as a member of the board of trustees, you abide by the decision that the board made. And so to the extent that the media is trying, particularly for the those in the minority on a vote, to get them to sort of, sour grapes, et cetera, I would just suggest that it is always a good idea to say, I made my opinions and my belief, what I believe on this issue clear during the public meeting. The board, however, has voted, and I'm going to abide. I will respect the vote of the board. If an opportunity arises to revisit this issue in the future, we will do so. Because ultimately, you still are a member. Like you have no. I mean, you are still have an individual, and your personal beliefs and views are. We're not trying to trample them, but you also have a duty to the board to ensure that you're speaking and acting in accordance with the board's majority votes.
Excellent point.
The only other thing I would add is when Board of Trustees members, they should be communicating with their wiu.edu email address. And reminder not to use their work email address or their personal email address because it causes a lot of problems under the Freedom of Information Act. So it's very important to use their actual VOT email address.
Yeah, I would absolutely agree. And this point is, we talked about emails, we talked about some of the cases that have come down where, personal emails were released because they related to public business. We talked about the Rahm Emanuel case and the Chancellor case. You obviously can't get around FOIA by using your personal email. And also it just creates a lot of difficulty when the board when I'm sure Liz, as a FOIA officer, is trying to gather responsive documents to try to delve into your personal email is always a challenge. And then we're relying on you all to get all the documents together, and that can be a source of, it's time consuming, it's confusing, and just documents will be missed. So always good to just use your WIU address. Okay. I'll keep going, but again, no need to we can go back. So this part of the document relates to relationships with the WIU administration and governmental bodies. Obviously, there's lots of issues always going around. So the chair, the vice chair, the president will represent the board in collaborating with or informing governmental bodies about matters pertinent to the university. There's a usual chain of command. We recognize that orientates virtually all professional boards and hierarchical administrations. We resolve, therefore, to respect the hierarchical progression by routing our complaints, ideas, or questions to the next higher person in the usual recognized chain before forwarding these matters to any government body. We agree that relaying rumors, innuendos, and anonymous emails, unsigned allegations, or other highly derogatory information to government bodies is detrimental to the interests of WIU, and trustees will not do so without informing the chair, vice chair, or president of the intent to forward such information unless required to do so otherwise by law. Obviously, we're not trying to run afoul here of any whistleblower or when you have a duty or a requirement to alert, if something that is being done on the board that you believe needs to be reported, the document is absolutely not trying to prevent that. But really the idea is that, again, as you speak as a board in relationship to the public, which we just talked about the media, or as you talk with other, obviously WIU is a state university, so as you talk with other governmental bodies, that those communications are going through regular chains, and so the information is consistent and consistently provided. We pledge to maintain an open and transparent dialogue with WIU administration when we as trustees have a matter of concern, questions about any WIU matter, or particular issues that should be attended to. We agree to start the discussion of an issue with the president and or the chair, unless otherwise required to do so by law. Or if the concern involves the president and or chair, we will contact the vice chair. So again, the idea is there are going to be issues that you are unhappy with, absolutely, but this is giving you a mechanism. Doesn't mean you can't bring them to the rest of the board if necessary. We pledge to seek information broadly, to listen to campus constituent groups, to question campus leadership, and to listen to many and varied opinions about campus issues and concerns. Trustees are encouraged to visit campus as often as possible and to show support for the work of the university. Attendance of specific events to which trustees have received a special invitation is appreciated when possible. If trustees have committed to attending events via RSVP but become unable to attend, they will notify the university that they will not be in attendance. Again, just you obviously set a tone, so the idea is just to make sure, and again, the end is just that you're committed to open and honest, transparent, and respectful interactions, and that you agree to the above stated guidelines. Again, I'm not suggesting that you all sit down and sign this today, but I think I wanted to provide this draft. Again, some of it I think came from communications discussions that I can't speak to between the vice chair and the chair. Some of it was that we have created internally as we've seen boards. But again, just like the rules, the idea is to create a structure, some guidelines, meeting norms, so that everybody understands what to expect and everybody is abiding by the same guidelines when in communication with each other and with others. So any comments, questions, thoughts? I mean, again, I can leave this document with you to have debate about. You can discuss it now, however you want to go. Okay. Well, we can certainly come back to this if needed. I'm going to stop the share and put back my. Okay.
Nikki, can we pause just for a second? Do any trustees have comments about any of the document?
I got the clarity that I need. I'm fine with that. I think it'll help us have more efficient meetings. And you know, I think it's a good step in the right direction.
I agree. Good step in the right direction.
Yeah, I also agree, but I'm not gonna be repetitive and go through that. But
Okay, well, I'm at your disposal in terms of discussion of this later. Okay, again, you know, functional boards, being a functional board is a complicated process. Again, our goal here is to make sure that everybody has full information, that everybody's fully heard, and that your meetings are as productive as they possibly can be. Understanding that everybody's going to come at these with a lot of different opinions and feelings and thoughts and interpersonal issues that are not going to be solved by a document, but perhaps we can get on track in terms of our meetings and our communications. So the last piece of this section is just about the board responsibility versus the administration's responsibility or their role. I don't know that I can, you know, make this, you know, absolute in any way. I would bring to your attention the board regulations. You do actually have a board regulation that discusses this, which talks about the fact that, you know, that the board is responsible for ensuring that its policies and regulations are followed, but it shall not participate in the details of institutional management delegated to the university administration. Members of the board as representatives of the state and its citizens may exercise official board authority only when the board is in session or when trustees are acting on behalf of the board pursuant to its formal direction or specific direction. Committees of the board may be created and present proposals to the board for approval. So I think that boards struggle public bodies struggle with the difference between, a board's responsibility assuring that its policies and regulations are followed, its actions are followed, but not participating sort of in the details of the day-to-day administration that is delegated to the university administration. We'll talk about this issue in other places during this training for contracts, for financial oversight. I do think that this is sort of one of those things that is always a constant sort of issue of boards and how much they sort of get into the nitty-gritty and how much they don't. I don't know a lot about the trustees and their role in terms of their day-to-day with WIU. I know, you have a robust administration that provides lots of information and runs the day-to-day, and your overall goal, of course, is governance. So again, we'll talk about the specifics of this, but I did want to highlight that you have a board regulation specifically on point, and to think through that always, because the trouble, it becomes complicated when trustees start to sort of get down in the weeds on very specific administrative issues, because it becomes unclear whether they're speaking on behalf of the board or sort of what we don't want is board members micromanaging or feeling like they need to micromanage the administration. If you ever feel that sort of need or impulse, then the issue is one of talking to the administration as to why you're not getting the information or the specifics or the details that you're looking for, rather than trying to sort of jump in with 2 feet and micromanage. Again, not to suggest that board members should not be on campus. Again, the guidelines we just went through encourage folks to come, to talk to, to establish relationships, to talk to folks at the university, but obviously to respect that role. Okay, we went through quite a bit related to your board of trustees. Again, that was sort of the heart and the bulk of the things that I wanted to do. There's some other topics that we're going to go through, so we can move forward to those. I'm going to just keep going. I don't know whether you guys are going to do lunch or a break, so just Polly, flag me when you're.
We will be doing lunch. I think it may have arrived.
They're working on something. I'm not sure.
Yeah, they just walked out. Do you want to take a half hour off or?
Yeah, well, it's up to you guys. If lunch, this is a good time to sort of stop, because we're going to talk about we're just going to talk about contracts next. So this would probably make some sense to stop here if lunch is ready for you. You can take half an hour and then get right back into it.
Oh, it's not, we just had a no nod. It's not here yet. We're calling. Oh, she's calling. So
let's do
contracts. Keep going for. Okay.
Okay, we'll do contracts and then we can see where we're at. I mean, I know you guys, this is sort of, when we talk about audits, it may be only more exciting than the contract portion of this training. So we'll try to get through it. But Western Illinois University law, your state statute, obviously gives you the power to enter into contracts. For your university policy and procedures, as well as the statute, set out various requirements related to those contracts. I'm not going to go through all the details. Obviously, who signs, who approves the contract is dependent on the purpose and the size of the contract. Contracts, obviously, as you know, over 500,000, they require board approval. There's some other areas where they require board approval. And that is all set out in extensive detail in your policies and procedures. You have a detailed contracts policy, obviously, and you probably know this from having experienced various contracts that you all vote on versus the ones where you're getting updates from the administration on the contracts that they enter into. I did want to make a couple of points about, I wanted to mention another state law, which you are likely aware of, but just wanted to sort of put a fine point on it, which is that Illinois has the Business Enterprise for Minorities, Women's, and Persons with Disabilities Act, which requires all various state agencies, including state universities like WIU, to award a certain percentage of various contracts to minority-owned, women-owned, and disability-owned, people with disability-owned businesses. The act is specific about the requirements in terms of the percentages, also in terms of aspirational goals as well. You're required to have a policy to identify a plan for increasing your use of these contractors. There's an annual compliance plan in place. There's various enforcement mechanisms. This has and continues to be a focal point, certainly of the governor. And so, I would encourage you all as trustees to be aware of this requirement, to be, make it a priority to, if you're not getting the information from the administration, which I'm sure you are, about your compliance, just to keep that in mind. This is obviously, it's an entire state statute, and so it's important to the state of Illinois, and obviously you are utilizing public funds, and so this is the public policy of the state of Illinois. So did want to flag that. We talked extensively about, or not extensively, we talked about a bit about conflict of interest. Yeah, I'm sorry.
Can I just add one additional item on that about the minority contractors? One of the challenges we have as a university is a limited number of minority contractors who will operate in Macomb. Mm-hmm. And so if you as a board member can help us by identifying potential minority contractors, has to be approved, has to go through all processes and everything else. But if you can put us in contact with a potential vendor, we can go through and use our procurement processes to ensure that they're getting the information and having the opportunity to participate in the process. So whatever you can provide for us there can help us to better meet our objectives in that regard. Keeping in mind all conflict of interest rules and everything else that you have to keep in mind. But
yeah, I think that's such a great point. I mean, you all have connections in the community that are different than the administrations. So yeah, all hands on deck, definitely on that one. So
thank you.
It is worth noting that we have exceeded the state requirements. So it's really tough. We're out in the middle of nowhere and there just are not that many contractors, but we have done better than you would expect us to do. Not to say we can't continue to work on it. I'm not implying that, but we have done pretty well.
Yeah, I mean, it's obviously easier to fulfill these requirements in certain parts of the state where there's just more contractors. So you guys are limited by geography and population, absolutely, which is, yeah, I mean, the fact that you're meeting is great, always a good idea to keep pushing, and the fact that your board members in particular have different connections than is a great resource to tap. Okay, and again, I mentioned the conflict of interest, right? You want to make sure you're following that. We talked about the conflict of interest policy before. I'm not going to belabor the point. I do want to make note, I did before, but Western Illinois University law also discusses the fact that no member of the board shall hold or be employed or appointed to any office or place under the authority of the board, or be directly or indirectly interested in a contract made by the board. So there's also the Public Officers Prohibited Activities Act, which talks broadly about the board not being able to vote on a contract in which you have a financial interest. And there's a lot of specifics related to that and how these intersect, but it is not the case, particularly under the prohibited Public Officers Prohibited Activities Act, that you can really just abstain if you hold an interest in these contracts. You are prohibited from serving on the board in certain circumstances if your interest in a company exceeds certain statutory thresholds. So if at any point you believe that there is a vendor that is going to be approved, that you have a connection with directly or indirectly in certain circumstances, I would definitely bring this issue to Liz and you can sort through whether it's prohibited. So just flagging that for everybody. The only other thing I wanted to say on contracts, which is slightly unrelated, but just I think important to note, because it's another state statute that applies to the university, is that in 2016, the General Assembly had passed new legislation impacting employment contracts and severance packages for various the university presidents and chancellors. So it limits the types of severance packages that may be provided. So again, another contract issue that may come in front of the board. So just wanted to flag that law as well. Again, there's a number of overlapping laws here. related to contracts. If you are concerned about a contract or your interest in a vendor, again, I would raise that under your requirements in terms of any conflict of interest that it might pose before the university moves forward. So again, that's really all I wanted to talk about with contracts. I mean, it's obviously a big topic. You all have detailed university policies and procedures related to procurement, related to, and state law that intersects with that, related to procurement, related to the procurement, related to the specific purposes of the contract, who approves, who can sign, what is delegated, all of those things. I don't want to belabor these points. They are really set out in a particular level of clarity and detail. Obviously, like I said, if as the trustees you are concerned about any contract or procurement process, you should bring that to the administration, you should bring that to the chair. If you yourself have a concern about your own interests, you should bring that as well and loop Liz into that conversation. Liz, I don't know, did you have anything else you wanted to cover on contracts? Any questions or concerns about contracts? Okay, good. Trying to be efficient with your time on a Saturday. Okay, why don't we go through labor law and then hopefully and then we can probably take a break at that point. I know you guys have been sitting for a while. At some point, I think push comes to shove here, we've got to sort of stretch. So the university labor law, as you likely know or generally aware, you have, I believe, and Liz can jump in if I'm wrong, I believe you have 6 unions total. You have the University Professionals of Illinois, which is your main union, not your main union, your large union. And then you have you have 5 other unions that cover your laborers and your clerical staff. The university is covered by the Illinois Education Labor Relations Act. Obviously, state law covers labor law, state labor law here. You are a unionized setting. There are protected union activities that you have to respect. And there are circuits on which the university must bargain. My understanding is that the Board of Trustees generally do not sit on bargaining teams, nor does the president unless under certain circumstances, and this is handled by your Human Resources Department, your in terms of the University Professionals of Illinois, someone from the Provost's office, deans, chairs, those type of people who really understand sort of the day-to-day workings. Obviously, as board, you should be, and I likely are getting updates. I would flag for you, of course, that the University Professionals contract is up at the end of this year, so presumably your negotiations will be commencing in the next couple of months. And obviously, your role is to ensure that you are getting updates on the negotiation process as needed. There are, as a university, as a public university, you are subject, like I said, to state law in terms of what you must bargain. Obviously, for any of your unionized employees, you have to bargain wages, hours, any working conditions. You do not have to bargain what are management rights, and those are all very specifically set out in statute. Overall, you have a duty, the university has a duty to bargain in good faith with its unions and to comply with state law related to, again, concerted activity, union activity, providing access. Obviously, labor law has changed considerably over the last couple of years, particularly with various decisions from the federal Supreme Court, but obviously you all continue to negotiate with your unions. I know that you may be somewhat familiar right now with the grievance process in the unfair labor practice process. I understand that there was a ULP that was just filed with the university related to COVID and reopening. This is not an unusual issue that is arising right now, obviously, and a complicated one. But there is a process, obviously, from the union, individual union members, the union can, if they believe that the collective bargaining agreement is not being followed, they can file a grievance. If the union believes that the university is not negotiating in good faith or has violated labor law, they can file an unfair labor practice with the IELRB. All of these things have specific legal processes that they go through. Again, most of these probably will not reach the board level. Sometimes you might have some sort of high ticket items that do. Obviously, one of the key aspects of unions is that they protect union employees related to discipline and discharge. These are not at-will employees. You have very few, if any, I believe. So there's lots of rights that are inherent to that, which are set out in your union contract. Due process rights, rights to representation if they are going through the discipline process, various just cause, why and how you can be disciplined and for what, and ultimately terminated, and just the process and procedure that goes through. So again, all of these things are governed by your collective bargaining agreements with your individual unions, and are enforced through, again, the grievance process laid out in those collective bargaining agreements, and ultimately through state law mechanisms, what is in your collective bargaining agreements, the various unions, and any questions, concerns about labor?
Just for clarification, we have 8 labor unions. The university professionals, which is our faculty, plus another 7, which are mostly clerical and laborers.
Okay, thanks. I apologize. I missed you.
Lucky us.
If you want to talk labor unions, like there are some entities around the state that have quite a few. So you're not alone, obviously. As a big university, you cover lots of ground. So it can feel unwieldy at times when you have lots of different contracts at issue. But obviously, that's education is one of the few areas where we have not seen kind of reduction in the presence of unions that we have in some of our other fields. So again, good union management relationships can be very useful for the university. Obviously, you're going to have times where they are not as productive as other times, but the goal obviously is always to maintain a level of ability to interact and to work through issues. Obviously, I will say, just from an anecdotal standpoint, and not to sort of get myself embroiled in whatever issues you all are facing, but I will say that I think that COVID and the lack of, not the lack, but the individual universities, the K-12, obviously we hear about it a lot, the decisions to return, not to return, in-person, hybrid, remote, all of those different options have caused quite a bit of more sort of labor management unrest and disagreement than I've seen in quite some time. And hopefully, we can all move past this and get to a place where we work in conjunction again. But I do think it has been quite damaging to some of those relationships, and, understandably, but unfortunately.
So shall we take a half an hour?
Yeah, that sounds great. I think that puts us right in time, and I will continue with my stuff. So we should reconvene around 1, Polly, does that work?
Yeah, that works.
All right, let's go then.
Thanks.
Hey,
See you.
Keisha, before you leave, that document that we're looking at from earlier, the rules and regulations, would you be willing to add one on there that you'll agree with anything I say moving forward? Just think about over lunch.
Have a great lunch.
I'm not worried about it.
We're turned off. Okay, Nikki, we're ready.
Okay, great. I'm going to go ahead and turn off my camera with the hopes that maybe that the internet connection will be a little bit better. I am going to try to get through. I know you all have another meeting at 2:30 that you're going to be handling. So my hope and goal is that we'll get through the rest of this portion of the training in time, at that call, and then you all can then proceed to the remainder of the agenda. So I'm going to share my screen again. I want to turn now to, and again, if my internet connection is terrible, please let me know. I hopefully have corrected a lot of that and with the camera off, but I do apologize for the interruptions. I want to talk, the next topic that is a statutorily mandated topic, and obviously a very important one, is the issue of sexual violence on campus. My slide has to do with Title IX. I will be discussing Title IX in some level of detail. There's also state law that applies here that I will mention and go through with a little bit of detail as well. This is obviously a complicated area of law and something that universities have struggled with and have been grappling with. And there's also obviously new regulations. So I'm going to talk through a little bit of that. So I think most of you know, but I just want to, describe that Title IX is Title IX is a 1972 federal law. Most of us just refer to it as Title IX. It provides, it's in its essence that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal funds. So obviously the university receives federal education funds and is therefore governed by Title IX. I think Title IX, at least initially or originally, or maybe in the before the current time period, was best known for requiring gender equity in athletic programs. That was, the original, I think, the focus of a lot of Title IX was the lack of parity in sports programming. But its protections are obviously much broader than that. It prohibits sex discrimination, everything from admission standards to housing priority, course selection, club funding. All of those areas would be touched by Title IX. And of course, it also, as we know, prohibits all forms of nonviolent and violent sexual harassment. Nonviolent, name calling, slurs, suggestive conversation, and violent, of course, sexual assault being the most extreme. So we refer to that usually collectively as sexual misconduct. It's called sexual harassment under the law. It applies equally to students, to staff, and to faculty. So, despite, I think, what was sharp opposition, requests to delay from lawmakers, from attorneys general around the country, from educational organizations, certainly, the global pandemic being in full swing, I think folks were suggesting that the new Title IX regulations be delayed. However, the U.S. Department of Ed on May 6 did issue the amendments to the regulations implementing Title IX, and specifically the rules governing an educational institution's response to sexual harassment. So there were 2,000 plus pages of rules and commentary, including the department's responses to nearly 125,000 comments on the rules, which the first, for those who have been around the university for some time, the new regulations first appeared in November 2018, and it's been sort of an evolution since. The rules became effective on August 14th, 2020. It is now the law of the land in the world of education, these new regulations. Any activity that happened prior to August 14th is governed by the old regulations, but going forward, we are now governed by the new regulations. So what do you need to know about these regulations? Obviously, a lot of this is going to happen at the administration level. The board is rarely, if ever, involved in these types of Title IX violations, but it is you all need to understand and know the rules and what the university has to implement. Okay, so with some exceptions, the new rules actually narrow the circumstances under which educational institutions will be found to have violated Title IX by the Office of Civil Rights, OCR, that handles these complaints. So an OCR complaint, for those of you who are familiar, it is an administrative investigation process, but it can result in extreme circumstances in the withholding of federal funds. And so they do play a critical function in the enforcement of federal civil rights laws. So I would say that proponents of the due process rights of the accused are generally laud the changes, while opponents argue that victims of sexual misconduct in schools will now be inadequately protected. So, I think that debate is ongoing and certainly not one that we're going to solve in this training, but I think the rules were quite controversial. I do want to make the point and just remind that the new regulations do not govern the process for the investigation and resolution of a complaint related to athletic equity or other sexual discrimination, sex-based discrimination in the university setting. They are specifically related to this, the process by which a university handles a complaint of sexual harassment, again, that includes sexual assault. So there are new jurisdictional thresholds that now must be met before Title IX is implicated in these circumstances. Only where these standards are met must an institution apply the grievance procedures that are in the new regulations. What we have advised for our educational institutions, our clients, is you maintain the old grievance procedures that you had in place for everything else, for all those other types of complaints. But you implement the new process for those complaints that do fall under the definition of sexual harassment. So again, it has to be sexual harassment. It has to be sexual harassment as defined under the new regulations. It includes a quid pro quo of sexual nature by an employee, unwelcome conduct on the basis of sex that a reasonable person would find to be so severe, pervasive, or objectively offensive so as to effectively deny access to the educational program or activities. We commonly refer to this as sort of a hostile environment. And conduct that clearly meets the definition of what we call the big four offenses under the Clery Act, under the Violence Against Women's Act, sexual assault, domestic violence, dating violence, and stalking. This definition of sexual harassment, I want to be clear, is narrower than Illinois law. So you are also subject to the discrimination laws that exist in state law, including the Illinois Human Rights Act. And so again, if it meets this definition, it falls under Title IX and your Title IX process. If it doesn't, you can continue to use, if you choose, your old process by which you investigate and resolve these types of complaints. Another big change that is worth noting is that conduct must occur in a program or activity of the institution. The regulations narrowly define this as locations, events, or circumstances over which the institution exercises substantial control over both the alleged harasser and the context in which the sexual harassment occurs. The definition goes on to explain that this includes any building owned by or controlled by the university or by a student organization that is officially recognized by the post-secondary institution. Again, this is narrower than the old interpretation of Title IX. It is also narrower than the Clery Act and Illinois law. So what we can say is that most off-campus activity will not be implicated. Most off-campus activity that meets the definition of sexual harassment under Title IX is not covered. There are going to be circumstances, particularly under remote learning, for example, where it may be possible that off-campus activity, if it implicates, your remote learning platforms, et cetera, might be covered. But, that is a specific incident by incident investigation, but it is a considerable narrowing from what we had before. And the conduct must occur in the United States. That means the actual conduct has to occur here, not its residual effects, which was often OCR's interpretation under the prior guidance. So if something happened abroad and the argument was that it impacted someone's ability to access the educational program in the US, it was covered. No longer. The actual activity or conduct has to have taken place in the United States. So an institution is only required to respond to actual knowledge of Title IX sexual harassment. Again, I do want to remind you that under Illinois law, the institution is still required to respond to sexual harassment of which it knows or should have known. So I don't want you to think that just, that has been narrowed. It has only been narrowed in relation to Title IX. Again, you are still covered under state law, and that the should have known standard still exists in state law. And so let's say that you have knowledge, actual knowledge of conduct that would meet the jurisdictional definition requirements. The definition, it happened on campus, it happened in the United States. You must respond in two ways, and they're both critical, and they need to be set out in your policy so that it is clear. First, there's the initial supportive measures meeting that must occur in any case when there's a report that meets the jurisdictional requirements. It must be conducted by the Title IX coordinator or that person's designee, and must be with the complainant, the alleged victim, not any third party who reported it. So it has to actually be with the complainant, the victim of the sexual harassment. During the meeting, the Title IX coordinator or the designee must discuss the availability of supportive measures, which are available confidentially, with whether or not there is a formal complaint that's actually filed. So, and they have to, address the complainant's wishes with respect to these measures and notify the complainant that she or he can file a formal complaint. One thing I do want to also note is that only the alleged victim can file a Title IX formal complaint now. A third party may not. The Title IX coordinator has the ability to sign a formal complaint, but this should only be done in rare circumstances where there has been a report of sexual misconduct by an employee in a position of authority over multiple victims, and the complainant is either unknown or unwilling to participate. In most circumstances, it should be the victim themselves that is filing the formal complaint. Even when the Title IX coordinator themselves has to actually signs that formal complaint, they do not become the complainant. The victim, the alleged victims remain the complainants, and all of the rights and notices go to them still. So again, that first initial meeting, you have to identify the supportive measures. You have to ask if the complainant wants to file a formal complaint. It's the victim that needs to file that complaint, the alleged victim, I should say. Okay, so second, if and only if a formal complaint is filed, the institution must then adjudicate the complaint. They must go through the process. There is a number of steps that are laid out that they must go through. The first is the institution they're not required to provide an informal resolution process to try to resolve the dispute unless the complaint alleges allegations of sexual misconduct by an employee against a student. And in those cases, you should not be offering an informal resolution. But it must be voluntary. It must have, there's a number of notice requirements, the right to withdraw. However, the one critical thing is if there is an informal resolution reached, there's an agreement actually reached, then the institution can't reopen the allegations at any time in the future, even if the parties don't comply with the agreement. There can be other sanctions for noncompliance, which should be built into your agreement, but it can't be, the lack of compliance cannot result in the reopening of the complaint itself. The second step, again, if the informal process is not successful or there isn't an informal process, is an investigation. The university has to have an investigator who can be, it's not recommended that it's the Title IX coordinator, but it usually is someone else. There's a number of specific requirements that must be part of the investigation. There's notice to both parties the names of all known parties and the basic facts of the allegation. So the complainant and the alleged victim and the alleged perpetrator both get the same notice of that. Notice before any interview or meeting, so you have to let them know that we're going to be interviewing them. They have a right to bring an advisor of their choice to the meetings. And there's also a presumption that the alleged respondent or the alleged perpetrator is not responsible for the policy violations. So that presumption has to be applied through the whole investigation process. All of the parties have to be able to review all the directly related evidence that's collected at the end of the investigation and before the report is written, with 10 days to respond in writing. So very prescriptive, again, this investigation process. The investigator then reviews and considers those written responses before writing the actual investigation report. The report itself has to fairly summarize all relevant evidence. And then the parties and their advisors are given a copy of the report, and then again, another 10 days to respond to the report before any hearing is held. So again, lots of steps for that investigation now required. And then there's the final determination. The decision maker, who cannot be the coordinator or the investigator, makes a final determination. However, their higher ed institutions have to offer a hearing for all Title IX sexual harassment cases. Again, parties can bring their advisor. The hearing must include at minimum live cross-examination of parties and witnesses. There's a whole bunch of prescriptive type of rules related to if a party refuses to answer questions, the decision maker can't then rely on various parts of the statement. So even if a party does not show up at a hearing, there has to be an advisor for the. So if a party doesn't come or they don't have an advisor, then the institution must appoint one. Even if someone doesn't show up, a party doesn't show up, the institution has to appoint an advisor to basically conduct cross-examination and to conduct the hearing, to help conduct the hearing. Live cross-examination is the only thing that it requires at the hearing, but other processes can be used, like direct examination, as long as they're fair to both parties. The decision maker can ask questions of the parties at the hearing, and then after the hearing, the decision maker issues a final written determination that has to be sent to both parties at the same time. There is then an appeal process, and that also has very specific prescriptive steps that have to be taken regarding the appeal. So, again, just to impress upon you that this is, there's a lot of new components to this. So this applies in, when there is both student and just student on student allegations, employee to student allegations, or employee to employee allegations. This is actually a major change. So, and I want to again stress that the Title IX regulations use different definitions and rules than govern employee sexual harassment claims like under Title VII or the Illinois Human Rights Act. So when you're dealing with an employee on employee issue of sexual harassment that meets the definitional and the jurisdictional requirements under Title IX, it's going to look different than an investigation between employees that don't implicate the Title IX regulations. I think that this has added to a sense of confusion amongst higher ed institutions about how to implement, termination proceedings under collective bargaining agreements, how they intersect with Title IX. The U.S. Department of Ed would take the position that any post-termination proceedings would have to be integrated with Title IX hearing process. That's not always feasible. So I think that that's something that a lot of universities are still sorting through. I also want to stress, and I don't know what the university has or has not done in this regard, but there are a number of sort of Title IX team members that are a part of these regulations. The coordinator, the investigators, the decision makers, the appellate decision makers, and they all need to be trained on very specific Title IX requirements. And so that is something, you may be doing internally at the university. You may be, we are certainly providing those trainings to a number of educational institutions because of the extensive training requirements that do exist in these new regulations. And obviously your policies and your procedures, your websites, all of the information that relates to these to Title IX cases have to be updated. And I know we're helping a lot of institutions do that because all of this, a lot of folks are scrambling to deal with these issues, given, the fact that these sort of came down in the middle of a global pandemic. So I know your administration obviously is primarily responsible for implementing all of these different pieces of Title IX, the new regulations, as well as the old procedures that govern the remainder of Title IX, as well as, like I said, the Clery Act, Illinois Human Rights Act, Title VII. But boards should be aware, and obviously I know you are aware, that there is a lot swirling on these topics right now. I'm going to pause for questions in a moment. I just wanted to note two other pieces of law that are important to keep in mind. There's also the Illinois Preventing Sexual Violence in Higher Ed Act, which also has policy requirements related to sexual violence and domestic violence, dating violence, stalking, various requirements for the policy, notice requirements, different requirements, again, very similar, some of the similar components to Title IX. It also requires campus training and information regarding Title IX and sexual awareness, prevention and awareness. And likewise, your Western Illinois University statute requires sexual assault awareness education to all incoming students, whether through a seminar, through online training, or some other way of informing students. And, I will impress upon you that, when we see complaints related to Title IX, related to violations under, I'll speak to Title IX first. I think what we have seen with OCR in the past, which I would expect would continue, is that they are very concerned about process. They are very concerned about policies being aligned with process. They are very concerned about training taking place, that folks are aware of what constitutes sexual harassment, how they file a complaint, what the process is. You generally do not see OCR. It's not an across the board rule, but OCR is unlikely to overturn a decision of a university if there has been, adherence and, to processes and procedures that are in line with the regulations, and that folks have been trained, and that there is there's clear information to students, to staff, to all employees about how to report and how to file a complaint and what the process and steps are. So, I do think that we really emphasize adherence to these processes and procedures so that, again, the outcomes are done in a way that is fair and clear to all of the participants. Obviously, I know that the outcome of these decisions, even if you follow all best practices in policy and rules and regulations, can result in, unhappiness, public discussion and disagreement about the steps and the outcomes that the university has taken. That has certainly become more prevalent in the last couple of years. Difficult to deal with, no doubt, but certainly the first step is making sure that you're implementing and complying. One of the other things that I should mention, just because of what I just said in terms of folks posting on social media, folks discussing the outcomes of these investigations, you want to make sure that you, especially because of the tenor of these new regulations, that you are protecting both the victim and the alleged perpetrator from any retaliation or the like, because obviously retaliation is also still illegal under Title IX, although it is not governed by these procedures, it is governed by the old procedures. So I know that was a lot of information. I did want to just sort of get it out for the board because I think it's important to understand the sort of totality of the new Title IX regulations in a nutshell, as I've put them, but also sort of the other interlocking laws that apply here. I'm happy, again, to answer any questions that folks have. Okay, I know.
Go ahead, try again, Eric.
Nikki, thank you for the detail. I just had, maybe just for 100% certainty and clarification in regards to process, in particular as it pertains to this board. Also understanding that, when there is a case, there's a very high level of confidentiality involved with that, with these cases. Just for the board's understanding here, at what level will our board here become aware of certain situations? Is that at the conclusion in most situations of the final determination? I guess from this board's perspective, I would think that we would want to be advised and aware of what we can be made aware of, but we also realize there's also a lot of confidentiality in regards to that process. So I don't know, can you maybe just add a little more detail and texture as to, we want to be in the know as much as we can be in terms of privacy, but we also don't want to be caught off guard on anything either. And so I don't know if you can kind of summarize just in a quick note of how that would look like.
Yeah, I can certainly talk generally. I'm going to defer to Liz, though, on how you all do it typically. And you're absolutely right, which is that, the board's, ability or need to, ability to have specific information on students is regulated, and you only really get information on individual students or employees' specific situation, but students in particular, when you have a need to know them as part of your responsibilities as trustee. And that goes for any employee, also in the university, right? Just because you work at the university, you aren't privy to all of this information. And so, generally speaking, again, I would defer to Liz on how you all get information on these, but generally on most of these, as these processes are going through the various levels that we discussed, it is unlikely that the board will be informed of those as that process unfolds, because they are confidential processes. Liz, I don't know if or when the board is ever brought into these. Universities do this in a different way. Some university boards are more actively involved, so I'll defer to you on that.
Sure. Our board is not specifically involved in our cases. We keep them very confidential. The only time that they would probably know is if it was an employees that might be possibly disciplined or terminated, which we could discuss in closed session specifically about a specific employee. But as far as most cases, they will never have knowledge of them.
Yeah, I mean, and that's consistent with the way that a lot of boards operate. I understand that sometimes there is information that is released publicly that the board, then there may be need for an update because it has become public. But as it sounds like, and how most institutions do deal with it, particularly at the university level, as a board is not privy to the confidential, particularly student type allegations as that process unfolds.
Thank you, Nikki. And Liz.
Okay. Again, not an easy topic, but obviously an important one that everybody is dealing with across the country. Okay, I wanted to turn now to the concepts of duty of care and duty of loyalty. Again, these are sort of basic board issues, ideas, concepts that apply, to boards in the corporate world. They apply to public boards, and they're all, again, like conflicts, issues that I'm sure that you all think about, understand, but I think important to sort of go through. The duty of care really encompasses the idea that, there's a presumption that the corporate officers are making decisions affecting the public university in good faith, and with an honest belief that their decisions were in the best interest of the board, of the university, excuse me. Generally you're not personally held liable. You're indemnified by the actions that you take as a board member, as a trustee, as long as they've acted in good faith, with due care in the performance of your duties. Illinois case law defines due care as becoming sufficiently informed to make an independent decision, and that's applied, under the business judgment rule, which applies specifically to corporate boards, but is equally applicable to a public board. So again, exercising due care, becoming sufficiently informed, relying on information from your administration, from the reports that you receive from them, your information on finances that you receive, other data, understanding it, asking questions if you don't understand it, exercising good faith when you're then acting based on that informed judgment. The ways that where a trustee or a board member would be found to have not exercised that duty of care is if you engage in fraud or corruption or some sort of breach of trust. If you engage in a knowing conflict of interest, you're acting in bad faith. You are not motivated by the purpose of the university, those are the sort of the big ways in which a board member could run afoul of the duty of care. Again, even if you don't have all the information, as long as, again, that you're acting in good faith, or you're acting in what you deem to be the best interest of the university, and that was reasonable under the circumstances, that is going to certainly protect you from any individual liability, and that is going to demonstrate that you exercised the duty of care. This obviously overlaps with the concept of duty of loyalty or a fiduciary duty to the university. You need to be acting with the best interests of the university, and you obviously are all going to have different opinions about what the best interest of the university may or may not be. That's fine, but you have to be acting with that in mind when you're making decisions on behalf of the board. Again, we've talked about this at length. You want to avoid any special benefits, any conflicts of interest. You also really have to understand, which I know you all do, the mission of your university, and you want to act consistent with that mission. WIU has a very specific set of goals and mission that you want to bring to your community and to Illinois, and you have to act consistent with that. And again, we talked about this in a couple of different contexts today, but when the board acts, it takes action by the board. It's not by individual board members. And so ultimately, even if you disagree with the decision of the board, you are bound by that decision and bound to conduct yourself in keeping with that decision, until such time as the board, maybe overturns it or decides to go a different way. But certainly while that action has been taken, that is your duty of loyalty and fiduciary duty to the university. I am not going to belabor these points. I think they're fairly straightforward, but I'm happy to answer any questions, or if anybody wants to make a comment, again, happy to give space for that. Okay, we are cruising through. We may even make it in less time. You guys are post-lunch. Okay, financial oversight. So, obviously the board has financial oversight of the university. There are a number of components to this. You need to ensure, obviously, as the Board of Trustees, that you're in compliance with laws and regulations that govern your financial, your finances at the university. Obviously, the university has, you ultimately have oversight responsibility over the public funds and the private, but there's obviously extensive public funds, both state and federal, that are at issue. And you have a fiduciary duty to the university as well as to the taxpayers to provide appropriate oversight for financial matters. We're going to be discussing audits at the end, sort of go out with a big bang. But you do need to make sure your audit committee is on top of internal controls, risk management, compliance, all of those pieces are going to be components to accountability. You know, you want to identify and assess risks and proactively incorporate accountability into your structures so that your oversight is effective. So again, let's talk first about the overarching role. You have a clearly stated institutional mission. It's accompanied by a statement of visions, goals, priorities, and that creates the foundation for exercising financial responsibility as board members. One of your, duties, I would say, as a trustee is to have a basic understanding of the financial condition of your institution, so you are able to then effectively exercise your fiduciary responsibilities. Essentially, you as a board member should be able to explain what is happening on a high level with WIU's finances. I'm not suggesting that you need to have memorized every budget line or that you're tracking every expenditure. By no means am I suggesting that. But you should have a general overall understanding of the finances and what is happening with the university. Obviously, these are very complicated times for WIU and the state universities in Illinois. Funding, revenue, all of those issues are very complicated right now, and do not make it easy to be a trustee by any means. What we really want to avoid at an institution, particularly the size of WIU, is that the financial condition is the exclusive knowledge of one or two trustees or just the senior administration. It really needs to be that it is in the knowledge of all the trustees so that you all can exercise your fiduciary responsibilities and you're all providing oversight, because you're all going to have different perspectives on this, which is important. And you're responsible for ensuring that whatever financial decision-making you're doing, it's aligning with your strategic goals and your mission of the university, right? So it's not done in a vacuum. It's done, obviously, always aligned with those things. The last piece that I would suggest about the finances is that, again, and I sort of hammered transparency with the Open Meetings Act and FOIA, this is another area, obviously, where transparency is key. I just referenced all of those public funds, and so there should be no sort of obscuring of your financial process, and I know that there's not. All of these things, all of these discussions should be very open to the public, and obviously closed session. We talked about the examples where boards have run afoul of that. So that's really your overarching role in the financial oversight of the university. I want to talk just for a minute here about sort of some of the nuts and bolts, or how that actually sort of plays out at the board level. So I believe that you all did a budget discussion at your last meeting, again, reviewing, approving, monitoring your annual operating, your capital budgets, all of those, just the oversight of the university's budget is part of your responsibility. Certainly tracking key metrics. How is the university doing in terms of finances is also under the general oversight of the board. Engaging in long-range strategic financial planning. So how do you improve the finances of the university over time? Again, ensuring that sound financial controls are in place to the extent that they are. Making sure that you're reviewing them and making sure that they stay in place and are effective. Again, we've talked multiple times about conflicts of interest policies, making sure that those are up to date, making sure that you have policies that are up to date, consistent with current state law on your relationship with donors, your research, your intellectual property. All of those policies are going to impact your their overall finance, and making sure that those policies are in place and up to date and are being enforced. And again, being aware of sort of high level risks, what your highest risks are and what the safeguards are in place. Again, I'm not talking about sort of getting mired in details on that, but just getting sort of a general understanding of where the risks lie and what you have in place as a university to safeguard. This is really an area where I'm going to stress again that board administration relationship. So again, the board should anticipate and expect, and has a right to expect, that financial information that they need is provided. so that they can exercise this oversight. Obviously the administration cannot and will not and should not have to respond immediately to every information request that you throw their way. We really do not encourage boards to get mired into, every, how much you're spending on paper clips. Trust the administration to provide appropriate oversight, but again, or provide day-to-day administration, but again, making sure you have that high-level oversight at all times, and that, again, you can explain it to others is important. I would say, where this also plays out is if you are having to make strategic decisions, or, if you are in a position to have to make cuts. I know that that's not, something that WIU is not, has not experienced in the past. And so it is certainly something that I know the board is cognizant of. So if you are making strategic decisions, again, you all know this university much better than I. I'm giving you sort of an overview of how the law looks at these issues. I know that you are thinking about these things and don't suggest otherwise, but what you need to be looking at when you're looking at strategic decisions, or if you have to reduce spending in certain areas, is, again, ultimately being guided by the mission and the purpose of the university itself. Making sure that if there are stakeholders or constituencies that should be participating in the decision-making or providing information on what is happening at the university level on the financial front, that those voices are included, that they're heard, that they're incorporated into ultimately what you all decide to do. I think transparency, again, is critical here. Obviously, you have so many different stakeholders that have an interest and an investment in the university. Certainly your communities that you exist in have a huge interest. And so making sure that all of your decision-making is transparent. I think that one of the things that is super important when boards make decisions, particularly tough decisions, is that you're owning that decision and you're owning the narrative. There are so many times where it is going to be an emotional issue, right? If you have to cut a program, or you have to reduce spending in a way that impacts a specific constituency, you have to understand that and be compassionate and sympathetic to it, but own the decision that you ultimately make as a board. Because obviously the sort of buck stops with you, so to speak. And that means also supporting campus leadership if they have to do these kinds of strategic decisions, because ultimately the board is going to have full oversight, and you need to support the decisions that your administration is making. So again, I know that this is stuff that all of you know. It's the idea of providing leadership on financial issues is so critical, particularly in lean times. Obviously, in abundant times, it is helpful, but in lean times is where it sort of push comes to shove. So I did want to sort of make a specific point about it when we were talking about financial oversight. So again, big ticket, statutory responsibilities, overarching roles, and then, obviously your key components of your oversight, and then how to think about making those financial decisions. Questions, concerns? Okay. This is actually my last topic, so I'll probably get through this by 2. I know you have something at 2:30, so I don't know if you want to move that up. We're sort of, sometimes this takes longer if we have lots of questions, but I think we're getting through it. So I'll plan to finish around 2 if that works. And again, if there's questions about there's a lot of discussion on auditing. We can certainly go longer if people want. Okay, what we've all been waiting for, fiscal control and auditing. This is an important topic. It is actually a statutory topic, which is why we are here today and why I am sharing it with you. But it is a super important topic, and there's a lot of components to it, which are not always sort of super clear at the outset. So hopefully this will take you through the high level. I will tell you that I'm not a particular, I understand the basics of state auditing law. So I'm happy to walk you through that. You all would, get any specific answers related to WIU would come through from your audit committee, which I'm sure is happy to provide those. So I'm going to start with the Fiscal Control and Internal Auditing Act. Essentially what that act does is it requires you to maintain a full-time program of internal auditing. You have to have a 2-year auditing plan. You have to have an annual report on how the plan was carried out. And you have to review a review of all your major systems every 2 years. This act also created the Internal Audit Advisory Board, which creates a set of professional standards, a code of ethics to which all state internal auditors, so your internal auditors, have to adhere. There's training components to that under the statute for your internal auditors, and peer review. There's a number of different processes. So ultimately what this act does is it requires you to maintain a system of fiscal controls and to have that auditing plan. There is another state law, the Illinois State Auditing Act, which does, among other things, creates the Office of the Auditor General. They have audit jurisdiction over state agencies, including state universities. The Auditor General is a constitutional officer of the state of Illinois, and essentially they are charged with reviewing the obligations, the expenditures, the receipt, and the use of public funds. Again, lots of oversight when we're coming to public funds. So essentially what the Auditor General does is they audit the public funds of the state, they report the findings and the recommendations to the General Assembly and to the governor. So there's a number of different types of auditors that the Auditor General is involved in. There are financial audits and compliance examinations that are mandated by law. So these audits have to take place, again, focused on the obligation, expenditure, receipt, and use of public funds. They typically will provide agencies with specific recommendations to ensure that they're fully compliant with all of state statute, rules, and regulations. So they also review, the Auditor General is also charged with reviewing the compliance with federal statutes. So obviously your federal funds are governed by a myriad of federal rules and regulations. And so there's also the federal audit, the single audit, that the Auditor General is required by law to oversee as well. So those are the first set of mandatory audits that are required. The second set are performance audits, which are conducted at the request of legislators to assist them in overseeing the government. So, state programs, state functions, what they want to look at are reviewed according to the direction of the scope of the audit. And again, the General Assembly then uses these recommendations potentially to develop legislation for government improvement, or if there's an issue that is persistent, on how to try to create solutions through legislation to audit issues that they're seeing, to performance issues that they're seeing. And then the last is information system audits that are performed on the state's computer networks. So again, they're looking at controls within the state computer system so that they are adequately protected against any breach of financial or confidential information. So that is the overall and very exciting role of the Auditor General. There is also the Legislative Audit Commission. For anybody who's ever been before the Legislative Audit Commission, the audit reports that the General Assembly receives are reviewed by the Legislative Audit Commission in a public hearing attended by the audited agency's officials. Testimony is taken from the agency regarding the audit findings and then the plans the agency has for corrective action. So again, it's a process by which the General Assembly exercises oversight and control over state agencies, state universities. When I was at the Illinois State Board of Education, I had the pleasure of going before the Legislative Audit Commission on a number of occasions to try to sort through some of the audit findings that we have. I'm sure that you all have had some experience internally, or your internal folks have, on this issue. So as I referenced at the beginning of this section, WIU has an audit committee. They are responsible for the oversight of the quality, the integrity of the university's accounting systems, their auditing processes, their external financial reporting, their legal and regulatory compliance practices. So they have a lot of oversight over all of these pieces that are obviously essential to making sure that the controls of the university are in place. So again, one of the things that the internal audit committee is going to look at is internal controls, making sure that all of the processes, the procedures are in place to make sure that you have adequate controls over how money is spent, how you are complying with all of the myriad, like I said, myriad state and federal regulations that you are subject to. They also have oversight over the, or they work with the Auditor General and the Illinois Office of Executive Inspector General and other audits performed by independent. If you have independent audits performed, they would have oversight over all of these, or all of these external audits. So they are going to be working with anytime, again, the Auditor General is involved or any external auditor. They also will have oversight over the internal auditing. So you have, again, WIU has an Office of Internal Auditing. And so the committee has general oversight over internal auditing. So you guys have a policy on internal auditing. And so the committee is involved with your auditing department to make sure that they're reviewing any reports and any material conditions or concerns, making sure your audit plan is in place and consistent with state and federal law. The summary of the audits that you guys receive, if there are audit violations, and then again, reviewing the controls that are in place to make sure that that you are following your plans, and also making sure that you're identifying any risk. The committee is also just looking at overall university compliance, again, legal matters, risk management, all of the stuff that we have been talking about throughout. So your audit committee, and through its work, also looks at all of those internal pieces. So again, I mean, the theme here today, in large part, a lot of it is just to ensure that the structures are in place to make sure that you are complying with sort of the nuts and bolts of state auditing and federal auditing law. The bigger picture item under audit that I think can be stressed is just that this is the ways in which you understand where there are risks, where controls need to be shorn up or changed or augmented or improved, and then ultimately, making sure at the end of the day that you have full compliance as possible with your legal and regulatory requirements. So that is all I was going to discuss related to audits. Again, a lot of information about state law. I'm happy to, again, answer any questions about this or about any of the other pieces of, if you suddenly have like the most amazing Open Meetings Act question, I'm happy to answer that now as well. If there's anything else that you'd like to discuss, happy to go into that.
Vicki, I have a question about audits. Could you, is the mic on?
Yep, I hear you.
Oh, okay, good. This happened several months ago, but a legislator asked me about something that had happened at WIU, closing down a program. And I asked the auditor to investigate this, and he did a great job. He gave a very thorough investigation of this situation. When this investigation was ongoing, I informed Martin that I had spoken with the auditor and that I had asked him to do this. He ultimately found that there was nothing really to be concerned about. But what if he had found something? What is our responsibility as a board if the auditor had found that this was in some kind of violation?
Right. So, I mean, it's a little hard to speak in the abstract, but without understanding the specifics. But if your role of the trustees at that point would be to direct the administration to, first of all, if there needed to be a corrective action, implement a corrective action to whatever had occurred. And then if there were insufficient internal controls, or if it resulted, if it was a situation where the shutting down of the program was not done consistent with, university policy or procedure. If that was just because, of individual negligence, that's sort of one thing. But where was were there internal controls that did not exist that then resulted in the violation or the issue. So I think what it is the trustees directing the administration to, to look at, again, both corrective measures that could be taken or should be taken in relation to the program itself, and then ensuring that internal controls are there to make sure it doesn't happen again. Now, in terms of the legislator, obviously it would likely be a report back to the legislator and then a discussion about whether there would need to be more formal communication with the General Assembly about the issue, again, depending on what it was or the level it rose to. Any other questions, concerns? I know, Paula, we were a little bit early on. I hope that doesn't put the board in flux.
I don't think we get too upset when we finish early.
Yeah, I have to say that you guys have had some great questions, but less questions than I usually get. So I built in more time for that. But I do want to say it's been quite a pleasure to be with the board. I am sorry that I couldn't be there, or we couldn't all be together in person. It's always nicer to see everybody face to face and meet you all face to face. I will say on behalf of the firm, we have greatly enjoyed and appreciate the opportunity to work with WIU. The opportunities that we've had thus far. Obviously, it's a relatively new relationship. We appreciate it. We're happy to continue, and that's my contact information in the event that anybody needs me. But we certainly, as I said, greatly appreciate the opportunity to do this training and to do other work with the university. I'm more than happy to, like I said, you guys have the draft documents. In terms of the rules and the guidance, if there's a meeting at which you all want to discuss that further, or I can be of any other assistance in terms of as you work through those documents, if any changes, I'm happy to provide that at that point as well. Or if, again, any of you have any questions about any of the topics we covered or others today, I'm happy to answer them as we move forward together.
I know we're trying to end, but I want to go back to the section, the Title IX.
Oh, sure.
So as I'm trying to understand it, it's the law changed because the original specifically addressed sexual harassment. But
no.
I imagine this is still somewhat personal, right?
You're sort of going in and out for me. I'm sorry. I think maybe mute the room and then I can hear. Just that's better. I'm sorry. So Karen, the question was whether Title IX originally covered sexual harassment.
That it did, right? But I don't know. You can tell me that. I guess what prompted the change, and is it less liability for a university now?
Okay, so yeah, no, that's a good question. No, so Title IX always covered sexual harassment. It always covered sexual violence. What the law essentially provides that you can't be discriminated on the basis of sex or excluded from participation on the basis of sex in any educational program. That has always been interpreted as including sexual harassment, as I said, including sexual violence, sexual misconduct. Then there has always been a series of regulations that the U.S. Department of Education puts out. You know, the U.S. Department of Education puts out regulations on all sorts of federal laws, right? FERPA, all of the federal laws that fall under their purview. So they had issued a set of regulations about Title IX that covered every aspect of Title IX. So it covered the sports equity issues, you know, admission standards, housing, all of the things that Title IX covers, and it also included sexual harassment. At some point a few years ago, and I probably can't give you a full breakdown of sort of the why and the wherefore, but began a debate, and I would say certainly under Secretary DeVos, about whether what was happening with Title IX cases specifically related to sexual harassment on campuses, college campuses were the primary target, although these new regulations apply to K-12, that the pendulum had shifted too far, I suppose, is the way that they would argue, that there was too many rights afforded to the alleged victims, and there were not enough rights afforded to the alleged perpetrators, and they were resulting in skewed decisions in this regard. Again, this is a debate I don't want to wade into from a substantive standpoint, but that was, I think, some of the public debate and discussion. And so the rules, the new regulations, the ones that I went through specifically, have to do with just the application of Title IX in the area of sexual harassment. I highlighted that because it's new and you likely have not been trained on those issues. Again, they were changes to the way a university, the jurisdictional elements that when sexual harassment actually does fall under Title IX, and then if it does, what the processes and procedures are used under that. There is still sort of the old set of regulations that apply to all other aspects of Title IX. And then there is also state law and other federal laws that sort of intersect here. I hope that helps a little bit.
Yeah, I'll definitely read more up on it, but thank you for that additional information.
Yeah, absolutely.
You're good. Good. Nikki, could I've come a little lost in the differences between Title IX rules and state rules. And what I'm kind of questioning is if we need really two sets of processes through which we respond to a Title IX issue that would be different from the ways that we would respond to a sexual harassment issue brought under state rules. I mean, they could be similar, but we would need to have two different, at least because they're the jurisdictions, well, not jurisdictions, but what can be brought under each of those rules is different. Is that what I'm understanding?
Yeah, so let me break it down this way. It might be more helpful. So the definition under Title IX now of sexual harassment is much narrower than state law, okay? So if a situation rises to the level of sexual harassment under Title IX, then you use the new process, okay? But you will also, in that regard, be complying with state law at the same time, okay? So those will overlap in terms of the Venn diagram, okay? So essentially there is a narrow range of sexual harassment conduct that is now under Title IX that you will use these processes for. If it does not meet the definition of sexual harassment under Title IX, this new definition, you can use your old process that will both meet the definition under state law and under things like the Clery Act. So you would, in effect, have two different sets of processes, but it's not as if you were going to run. You don't have to run an investigation if conduct meets the definition of sexual harassment under Title IX, under these new regulations. You don't have to run two separate processes. Your Title IX process will allow you to comply with Title IX and also state law. Does that help?
Yep, that's good. Thank you.
Okay. Again, I would definitely encourage, I'm not certain of the university's plans, but the training for this, for Title IX, the new regulations in particular, for the Title IX team, but also for your, across the campus, has specific requirements. I just sort of went through high level because sort of so the board can understand what's happening. I know that new rules have been in the news, but the folks on the ground at the administrative level really do need to have that robust training that is required under statute, because it obviously goes into much more depth about how to deal with all of these different pieces. We have some toolkits and policy drafts that we can certainly help with as well if that becomes useful.
Right.
who've gone through a training process. So we're in good shape, I think, on this.
And she has more plans for training in the near future.
Yeah, I mean, it's obviously an ongoing process. This is not an area where it's sort of one and done. So I know you all are going to be implementing robust plans. This is obviously a huge concern for universities, as is all other sort of discriminatory behavior. But you know, this is sort of the high ticket item. It's also you are obligated to understand this as board members through the board leadership training. So I did want to touch on that. Obviously, there's both federal and state law that prohibits all kinds of discrimination on campus that you all adhere to, and I know are contained within your policies and procedures as well. That's all I have for
Well, we so appreciate it, Nikki. You're going to have to go and bathe your throat tonight because you've been really having a lot of individual conversation. Usually there'd be more give and take here. But thank you so much.
No, again, it's been my pleasure. And again, I appreciate your patience. I know a lot of this is rote and routine for a lot of you, and you've been through it. So I do appreciate it. It's great to see you guys, albeit remotely. And hopefully we'll, again, see each other in person someday soon.
Thank you,
Hope
Nikki.
so. Thank you.
Thanks, Nikki.
Thank you.
Yeah, let's do that. We're so close, so why don't we hear the one public comment?
Oh, sure.
And then we'll take a break and we'll just come back at 2:30.
Okay. We have one public comment from Tom Blackford from the Department of Mathematics and Philosophy. In spite of what happened at the last Board of Trustees meeting, I still believe in this forum. You can do better. Western needs you to do better now more than ever.
Good. Okay, so do you want to come back a couple minutes before 2:30 so that we're all in place when we connect with our search consultants by Zoom? Good. Thanks. Okay, so this is for trustees. This is Alex Matthews and Betty Asher, our two search consultants from Greenwood Asher. And I'll turn it over. Let you do it, Betty.
All right, good afternoon, trustees. I'm sorry we can't do this in person, but we've gotten pretty good with virtual, so I'm hoping that this will work for you. We want to do two things today. One is just to give you an update on where we are in the search, where we've been, where we're going. And then lastly, and certainly most importantly, is I'd like to make a recommendation of best practice for the time when you will, as a full board, engage with candidates. At least it will be something for you all to think about and have some discussion about, either today or later. But it is something we need to begin to plan for at this particular time. We began our work, as you all know, right at the end of June. We began with one very important principle in mind that was articulated by our chairs, both orally and in writing. It was in our code of ethics, and it is something that we have articulated to everyone whom we've talked with about their potential interest. And that is that this will be an open and it will be fair process, that every candidate will get full consideration by honoring us with their interest in this particular position. And we are going to continue to reiterate that as we work with our committee moving forward to the next phases of the search. As I indicated, we did have the beginning of our search was to meet with our committee, get to know them a little bit. We did basically two primary agenda items with them at that meeting, and that was to talk with them about the attributes that important to them in their new president, to talk through the process with them, and to be able to finalize our marketing documents, and get ready to post advertising and that sort of thing. The other thing we did at that meeting was, of course, to review our code of ethics, which really is our standards of behavior as we go throughout the process. At this time, the committee members are actually reviewing candidate application materials, recognizing that there's more to come. We still have expressions of interest from people out there and people who have not submitted their materials today, but they are in the process of doing their review right now. So immediately, our next meeting will be right after Labor Day, and that will be an opportunity when the candidates will all be discussed. They will all be reviewed fully by the committee. The goal of that meeting will be to try to identify a subset of that group that they're going to want to learn more about, meaning that they're going to have an interview, a virtual interview with a number of candidates. Coming out of that, perhaps 2 full days together, we will continue to ask ourselves, which of these candidates do they continue to have an interest in? And those are the people that we are going to do the deep dive reference checking on. We're convinced, based upon our experience, that this is one of the most important things that we can do for our committees. And we will do 360-degree vetting. We will talk with supervisors. We will talk with peers and colleagues. We will talk with direct reports. And we will talk with people on and off their list. By the time we've finished our due diligence on each of those candidates, we will have probably talked with maybe up to 15 people about that particular individual. We will then report those findings back to our search committee. And that search committee will then make their recommendations to you of those candidates whom they would like to bring to the campus to give them an opportunity to meet with all the various stakeholders. Now, recognizing that come November, we may still be having to do this part virtually, and recognizing certainly we will definitely have to continue our social distancing and all of that. But we're hoping that we will have an opportunity for them to come to campus, and both campuses, so that they will have their questions answered, and all the people will have an opportunity to ask them whatever questions that they might want to know. So, and this brings me to my important point for you, which is really my question to you for today. My recommendation is, but of course, you know, you may have a better idea, and we're certainly open to that as well, but just a best practice has been that the board will need to conduct their own interviews with those candidates. And generally, what we'd like to have you do within open meetings laws and all of that, if we could have an evening and a day of your time in order to do that. The evening, I would encourage you to have an evening meal. We generally will break the one candidate out for a social event that includes not the candidate, but the candidate's partner as well. This is not an interview, but it's an opportunity for you to get a feel for some of their soft skills, get to know them a little bit as individuals, and that sort of thing. And then the next day, you would report back to the rest of your colleagues if you observed anything that gave you pause, what was exciting about your dinner, and then we will go directly into the interviews for the day. Those interviews are generally pretty informal, but we'll also have some standard questions that we will have available to you if you choose to use them. Generally about an hour and a half, or sometimes even 2 hours with every candidate that you have. So individually, it's kind of a long and tedious day for you, but it's generally a very pleasurable day as well. And of course, after your interviews, you will then have your own discussion about each of your candidates. By that time, you know, when we bring those candidates to you, you will have the benefit of the feedback from the committee. You will have feedback from the campus broadly, all of the stakeholders that they've had an opportunity to meet with. And then, of course, you are to make your own decision. But we really do encourage you, if it is possible, for you to engage in some social time with them. I know all of you know that it's rarely the credentials that causes someone to fail. It's generally those soft skills. And it's a good way for you to get a really good feel for who they are and how they behave in a social setting, and et cetera. So that's my best practice. That's my recommendation to you. But like I said, you may have had other conversations about how you would like to engage with your candidates at the end. So let me stop there and see what thoughts you have.
I have a question. I thought I heard from you. Are we still accepting applications?
We are definitely still accepting applications. Mm-hmm.
Hey, can you speak about the size of the candidate pool, the diversity of the candidate pool, or is it all at this point confidential?
Well, let me beg not to answer that question. Will say to you, it is a diverse pool. It is indeed. I wish it were 75% diverse. It is not as diverse as ideally any of us would like, but it is a diverse pool. I will promise you that I will give you every number that you want at the right time, but I'm a little bit reluctant to do so now, because if I give you a big number and somebody is still considering that they want to come in, you know, they may not come in thinking that the competition is too great, but if I give you a small number, then they may wonder what's happening out there at Western. So let me beg right now to withhold that answer.
Okay, I'll ask another question then. So as the committee narrows down the candidate pool, approximately how many candidates will we as a board see?
The charge to the committee was to present you with from 3 to 5. I can tell you that generally they will select somewhere from 8 to 12, you know, for a round 1 of interviews. And then it varies how many they want us to do the vetting on. If they like all of them, we'll vet all of them. And the reference feedback meeting is when it becomes important for them to really narrow the pool down further. 3 to 5.
Okay, thank you. And do you have a kind of approximate target date for the full day, or?
We do. Let me answer 2 things there. One you didn't ask, but we designed a schedule trying to get the search completed by the first week of November. So our hope is that you will be available that first week of November in order to do your interviews with the final candidates. And as I said, generally we do it in a full day, sort of interviewing the candidates back to back, and board members do it differently. Some would like to have an hour and a half with them. Others would like to have 2 hours with them. So it just depends on your preference.
Thank you.
I do want you to know, I don't know who chose your committee. I don't know who chose your chairs, but I'm delighted with our chairs and delighted with our committee. So you chose well, and I appreciate that.
Not surprised. We have some amazing dedicated people that love WIU. So I know there's a lot of passion around this.
Absolutely. That is so true.
Questions? Greg? Justin?
I have one more. At this level, how, as we get down to these final 3 to 5 candidates, how confident are you that if any of them are offered the position that they're more than likely to accept? Do you feel like your vetting process gets some good insights to whether they're really ready to move to Macomb? You know, people drop out at the last minute.
That's an excellent question. I can tell you that we've worked very hard to try to get any of the blockers out of the way early in the process. So if we discover that there is a particular issue, we would be bringing that to your chair's attention. We've also, obviously, everybody is always concerned about salary. They know what, you know, previous salaries are because they're, you know, public information. That has been talked through. If anyone has a partner hire request or anything like that, we will know that as well. So we do our best to try to get out of the way, you know, any of those issues before they become finalists. And we actually will ask them very specifically, will you take the position if an offer comes?
Thank you.
Something couldn't come up, but we worked really hard to try to prevent it. We actually have them fill out a compensation form, and as you know, we don't ask for current salary, but we do ask them if there are any issues in particular that they need to discuss with the trustees in order to take the position. Well, everyone, please know where we are. If you do have any further questions, we're more than happy to respond to those at any time.
I will just say for the rest of the board's sake that Eddie couldn't come right out and say it, but when she was referring to how wonderful it was to work with the committee, she was referring specifically about me.
We thought that was the case, so we didn't want to say anything.
I just didn't want anybody to get confused. Thanks, Betty. It's been wonderful working with you too.
All right, thank you all very much.
And you too, Alex.
All right.
Anybody else? Well, thank you so much for taking time out of your Saturday to meet with us.
Anytime.
We really appreciate it.
All right, we'll leave you now.
Thank you.
Okay, thank you.
Thank you.
Okay, I think that winds us up. Do we have a motion to adjourn?
So moved.
Move to adjourn. Second.
Do we do all in favor, or do we have to do a voice?
All in favor, it's voice vote. No, because it's electronic, you have to do roll call. Oh, no. Roll call, okay. Shaw,
Yes.
Brown,
Yes.
Lang,
Yes.
Stutz,
Yes.
Billslaughter,
Yes.
Aguilar,
Yes.
Toomey,
I do not want to adjourn. I really like visiting with everybody. But yes.
Radash.
Yes.
Okay, unanimous.
Okay. Meeting adjourned. Thank you all.
Thank you.
Great day.